Bon après-midi à tous.
Good afternoon, everyone. I would like to declare this meeting begun. Welcome to meeting number 299 of the House of Commons Standing Committee on Industry and Technology. Dear colleagues, I am happy to see that people are in a good mood. I hope that that mood will last for the rest of the meeting. Pursuant to the order of reference of Monday, April 24th, 2023, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. I would like to welcome our witnesses today.
Today in person, Mr. Barry Suckman, Senior Counsel for McCarthy Tétrault. We have online Elizabeth Denham, Chief Strategy Officer with the Women's Legal Education and Action Fund. And we have Kristen Thomason, Assistant Professor at the Peter Allard School of Law at UBC, joining us also by video conference. So thank you to all of our witnesses. And each will have 5 minutes, but I see before we start, Mr. Perkins has a point of order. So, Mr. Perkins.
Thank you, Mr. Chair. Quick point of order. The motion that we passed to produce the draft amendments for PIPEDA, the long compromising meetings that we had, which was also done with the understanding that before we start ADA, that the government would table the draft ADA amendments as well. We gave the extra 6 weeks of the study. So I would just like an update from the government, if possible, about the tabling of the draft ADA amendments from the minister.
Thank you, Mr. Perkins. We'll follow up with the department and myself and the clerk. We'll see where the department's at in the minister's office on the said amendments, because it is true that we are nearing the end of the privacy part of our study on C-27. So it would be forthcoming. It would be good to have these amendments forthcoming. So I'll reach out to the department. Thank you, Mr. Perkins. And on that note, and I apologize, I believe, Madame Thomason, you're also with the Women's Legal Education Action Fund, so apologies for that. But we'll start without further ado with Mr. Suckman for 5 minutes. The floor is yours.
Merci beaucoup. Thank you very much for the opportunity to appear. I am Senior Counsel with McCarthy Tétrault with a practice focused on technology, intellectual property, and privacy. I'm the author of several books in the field, including an 8-volume treatise on computer, internet, and electronic commerce law. I'm here in my personal capacity. Although my remarks will focus on ADA, I've submitted to the clerk articles published related to CPPA and ADA, which contain much-needed improvements, and you can see that my submission is substantial. In my view, ADA is, my remarks are going to focus, as I mentioned, on ADA. In my view, ADA is fundamentally flawed. Any law that is intended to regulate an emerging transformative technology like AI should meet certain basic criteria. It should protect the public from significant risks and harms and be effective in promoting and not hindering innovation. It must also be intelligible. That is, members of Parliament and the public must be able to know what is being regulated and how the law will apply. It must respect parliamentary sovereignty and constitutional division of powers and employ an efficient and accountable regulatory framework. ADA either fails or its impact is unknowable in every respect. ADA has no definition of high-impact systems, and even with the minister's letter that was delivered, has no criteria and no guiding principles for how AI systems will be regulated. We don't know what the public will be protected from, how the regulations will affect innovation, or what the administrative monetary penalties will be. We know that fines for violating the regulations can reach $10 million or 3% of gross revenues, but we have no idea what the regulations will require that will trigger the mammoth fines against both small and large businesses that operate in this country. In short, none of the key criteria to assess ADA are knowable. In its current form, ADA is unintelligible. ADA is, in my view, an affront to parliamentary sovereignty. ADA sets a dangerous precedent. What will be next? fiat by regulation for quantum computing, blockchain, the climate crisis, or other threats. We have no idea. Ada also invokes a centralized regulatory framework that leaves all regulation to ISED. This departs from the sensible, decentralized, hub-and-spoke, pro-innovation approach being taken so far in the United Kingdom and the United States, which leverage existing agencies and their expertise and avoids overlapping regulation. It recognizes that AI systems of all types will pervade all aspects of society and that one regulatory authority alone is ill-suited to regulate them. Rather, what is needed is a regulatory framework for a centralized body that sets standards and policies, coordinates regulation within Canada and internationally, and has a mechanism for addressing areas where there are gaps, if there are any. Ada also paves the way for a bloated and unaccountable bureaucracy within ISED. ISED will make and enforce the regulations, and they will be administered and enforced by the AI and Data Commissioner, who is not accountable to Parliament like the Privacy Commissioner. And the Commissioner is also not subject to any express judicial oversight, even though the Commissioner has the power to shut down businesses and to levy substantial fines. Last, a major problem with Ada is that its lack of intelligibility and guiding principles make it impossible to evaluate its impact on innovation. We need to recognize that Canada is a middle country. It is risky for Canada to be out in front of our major trading partners with a law that may not be interoperable with those of our partners and which may inadvertently and unnecessarily create barriers to trade. Our AI entrepreneurs are heavily dependent on being able to access and exploit AI models like ChatGPT from the United States. We should not risk create obstacles that inhibit adoption or realizing the maximum potential of AI or the continued growth of AI and the ecosystem and the high-paying jobs that it will create. AI is going to be as transformative and as important as the steam engine, electricity, and the microchip in prior generations. Canadian organizations in all sectors need open access to AI systems to support adoption and innovation and to be competitive in world markets. If we fail to get this right, there could be significant long-term detrimental consequences for this country. To go back to my first point, there is nothing in Ada to provide comfort that these risks will be avoided. While my opening remarks, Mr. Chairman, relate to Ada, I also have concerns about the CPPA, and we'd be glad to answer any questions you may have about Ada or the CPPA. Thanks you again for the opportunity to appear.
Thank you very much, Mr. Suckman. And I'll now yield the floor to Elizabeth Denham with the Information Accountability Foundation. Apologies for the mistake in my presentation. There was a bit of confusion, so the floor is yours.
Thank you very much. Good afternoon, Chair. Good afternoon, committee members, Madam Clerk, and thank you for the invitation to appear before you today. Hopefully my input will benefit the committee's important work. I speak from decades of experience as a privacy professional and 15 years as an information rights regulator in 4 jurisdictions. My ongoing work takes place really on the international stage, but it's backed by long-standing familiarity with our own federal and provincial privacy laws. When I became the Information Commissioner for the United Kingdom in 2016, that role really brought me into the EU's oversight board that administered the GDPR implementation. And that brought me into direct collaboration with all EU member states. That experience greatly expanded my view of data protection and privacy that was first cultivated at the federal level in Canada, in Alberta and British Columbia. During my 5 years as the UK Information Commissioner, I also served 3 years as the chair of the Global Privacy Assembly. And that position greatly expanded my horizons once again and enhance my knowledge of other laws, other cultures, including the Global South, the Middle East, the Asia Pacific. And to this day, the work that I do spans continents. But the issues of pressing concern are largely the same. And those are children's privacy and safety and the regulation of artificial intelligence. Looking first at Canada's CCPA from a global perspective, I see a big missing piece. And the legislation's language, in my view, needs adjusting so that explicitly declares privacy as a fundamental right for Canadians. Its absence really puts us behind nations who lead the way in privacy and data protection. The legislative package goes some way towards establishing expectations for AI governance, but it lacks specific and much needed protections for children and youth. In a study that I conducted through my work with an international law firm, Baker McKenzie, surveying 1,000 policy influencers across 5 jurisdictions, we found that all of those surveyed came to a single point of agreement that the internet was not created, not designed with children in mind. And all of those policy influencers felt that we need to do better to protect children and youth online. And Canada is a signatory to the United Nations Convention of the Rights of the Child. And I think Canada owes it to our young people to enshrine the right for them to learn and play, explore, develop their agency, and be protected from harms online. In the UK, I oversaw the creation of a children's age-appropriate design code, which is a statutory enforceable code. And the design of that code has influenced laws and guidance and codes around the world. And I'd be happy to answer more questions about that. Additionally, I believe the legislature should go further than it does to provide the Privacy Commissioner with robust enforcement powers. I exported my career from Canada to the UK in large part because I wanted to gain hands-on experience administering laws with real powers and meaningful sanctions. In Britain, privacy harms are treated as real harms ever since the GDPR came into effect. And one result of that was the leap in the UK Information Commissioner's finding authority, but other enforcement powers were equally powerful. Stop processing orders, orders to destroy data, streamlined search and seizure powers, mandatory audit powers, and so on. So these enforcement powers were mandated by a comprehensive law that covers all types of organizations, not just digital services, but a business of any kind, a charity, and a political party. So by comparison with the GDPR, Bill C-27 lacks broad scope. It doesn't cover charitable organizations who are not above misusing personal data in the name of their worthy causes. Neither does Bill C-27 cover political parties. It leaves data and data-driven campaigns off the table of regulatory oversight. Serving as a privacy commissioner at the federal and the provincial levels in Canada exposed me to towering figures in my field. And I think of Jennifer Stoddard, the former federal privacy commissioner, David Flaherty, the former BC Information and Privacy Commissioner, and their names recall a time when Canadian regulators and Canadian law was deeply respected internationally, when our laws and our regulators really served as a bridge between the US and Europe. And although commissioners who followed, Daniel Therrien and Philippe Dufresne, have continued to contribute internationally, Canada's laws have fallen behind any global benchmark. And I think we can recover some ground by returning to fundamental Canadian values, by remembering that our laws once led the way for installing accountability as the cornerstone of the law. So enforceable accountability, which means companies taking responsibility and standing ready to demonstrate that the risks they're creating for others are being mitigated. That's increasingly part of reformed laws around the world, including AI regulation. And the current draft of the CCPA does not have enforceable accountability. Neither does it have mandatory privacy impact assessments. And that puts us alarmingly behind peer nations when it comes to governing emerging technologies like AI and quantum. My last point is that Bill 27 creates a tribunal which would review recommendations from the privacy commissioner, such as the amount of an administrative fine. And it inserts a new administrative layer between the commissioner and against this development. But a similar arrangement does function in the UK. Companies can appeal the commissioner's decisions, the commissioner's assessment notices, and sanctions to what is called a first-tier tribunal. But that tribunal is not there to mark the commissioner's homework or to conduct de novo hearings. So I would suggest that if Parliament proceeds with a tribunal, it has to be structured appropriately according to the appropriate standard of review and with independence and political neutrality baked in. So as a witness before you today, I have a strong sense of what Canada can learn from other countries and what we can bring to the world. Today, Canada needs to do more to protect its citizens' data. Bill C-27 may bring us into the present, but it seems to me inadequate for limiting or controlling or making sure we have responsible emerging technologies. So thank you for hearing my perspective this afternoon, and I very much look forward to your questions.
Merci beaucoup, Madame Denham. Je passerai.
Thank you very much, Ms. Dunham. Now I will give the floor to Kristen Thomason.
Thank you so much, Mr. Chair, Madam Clerk, and committee members, for this opportunity to speak with you today about centering human rights and substantive equality in Canadian AI legislation. I'm a law professor at UBC, and I have been researching and writing in areas...
I'm sorry, we're not getting interpretation in French.
Madame Thomason will just make sure that interpretation is working, so I'm...
Sure.
Ça fonctionne, merci.
Ça fonctionne, okay. You can resume.
Sure, thank you. I've been researching and writing in the areas of tort law, privacy law, and the regulation of automated technologies for over a decade, with a particular focus on rights and substantive equality, including recent publications on safety in AI and robotics governance in Canada, and work with the BC Law Institute's Civil Liability and AI project. I'm here today representing the Women's Legal Education and Action Fund. LEAF is a national charitable nonprofit organization that works towards ensuring that the law guarantees substantive equality for all women, girls, trans, and non-binary people. I'm a member of LEAF's Technology Facilitated Violence Advisory Committee and will speak to LEAF's written submissions that I co-authored with LEAF senior staff lawyer, Roselle Kim. Our submission and my comments today focus on the proposed AI and Data Act. You've heard this before, but if we're going to regulate AI in Canada, we need to get it right. LEAF agrees with previous submissions, emphasizing that AI legislation must be given the special attention it deserves and should not be rushed through with privacy reform. To the extent that this committee can do so, we urge that ADA should be separated from this bill and wholly revisited. We also urge that any new law should be built from a foundation of human rights and must center substantive equality. If the AI and Data Act is to proceed, it requires amendment. We examined this law with an acute awareness that many of the harms already arising from the introduction of AI into social contexts are inequitably experienced by people who are already marginalized within society. including on the grounds of gender, race, and class. If the law is not cognizant of the inequitable distribution of harm and profit from AI, then despite its written neutrality, it will offer inequitable protection. The companion document to ADA suggests that the drafters are cognizant of this. In our written submission, we made 5 recommendations accompanied by textual amendments to allow this law to better recognize at least some of the inequalities that will be exacerbated from the growing use of AI. The Act is structured to encourage the identification and mitigation of foreseeable harm. It is not requiring perfection, and in fact is likely to be limited by the extent to which harms are not considered foreseeable to developers and operators of AI systems. In this vein, and most urgently, the definitions of biased output and harm need to be expanded to capture more of the many ways in which AI systems can negatively impact people through, for instance, proxies for protected grounds, and through harm experienced at the group or collective level. As we note in our submission, the introduction of one AI system can cause harm and discriminatory bias in a complex and multifaceted manner. Take the example that we cite of frontline care workers at an eating disorder clinic who had voted to unionize and then were replaced by an AI chatbot system. Through an equity lens, we can see how this would cause not just personal economic harm to those who lost their jobs, but also collective harm to those workers and others considering collective action. Additionally, the system threatened harm to care-seeking clients who were left to access important medical services through an impersonal and ill-equipped AI system. When we consider equity, we should emphasize not only the vulnerable position of care workers and patients, but also the gendered, racialized, and class dimensions of frontline work and experience with eating disorder. The Act, as currently framed, would not seem to prompt a fulsome understanding nor mitigation of the different complex harms engaged here. Furthermore, as you've already heard, the keystone concept in this legislation, high impact system, is not defined. Creating only one threshold for the application of the Act and setting it at a high bar undermines any regulatory flexibility that might be intended by this. At this stage in the drafting, absent a rethinking of the law, we would recommend removing this threshold concept and allowing the regulations to develop in various ways to apply to different systems. Finally, a key challenge with risk mitigation approach, like the one represented in this Act, is that many of the harms of AI that have already materialized were unforeseeable to the developers and operators of the system, including at the initial decision to build the given tool. For this reason, our submission also recommends a requirement for privacy and equity audits that are transparent to the public to bring attention of persons responsible to as extensive prevention and mitigation as possible. I would finally emphasize the concerns about the resources required to mitigate harm should not dissuade this committee from ensuring that the Act will mitigate as much harm and discrimination as possible. We should not look to expand an AI industry that causes inequitable harm. We need a human rights approach to regulating AI for, among many other reasons, any chance of an actually flourishing industry in this country. Industry will also suffer if workers and small enterprises are not protected against harm and discrimination by AI. Public resistance to a new technology is often based in an understanding that a select few stand to benefit while many stand to lose out. To the extent possible, this bill should try to mitigate some of that inequity. Thank you for your time, and I look forward to your questions in the conversation.
Thank you very much. So to start the discussion, I'll now yield the floor to MP Williams.
Thank you, Chair, and thank you to our witnesses for being a part of this important discussion online and in person. Mr. Sookman, Bill C-27 introduces a large number of new terms to our privacy protection regime, which is then leaves undefined and open to interpretation. For example, the bill gives extra protection to the sensitive information of a minor, but it does not define what a minor is, nor what sensitive information is. The list goes on: reasonable person, legitimate business interests, appropriate purposes, and appropriate circumstances for data collection. Do we need to define these terms in the legislation? If so, how would you do so?
So thank you very much for the question. It's a really good one. One of the concerns I have about the CPPA in particular is that it creates these ambiguous new standards and requirements with open-ended type tests, like what would be appropriate or what a reasonable person would think. This is very, very hard for any organization that seriously wants to comply to know how to comply. The appropriate purpose is a good example. As for the definition of minor, I think it would be useful to have a common definition that applies throughout. In terms of sensitive information, I think there's already sufficient cases about what sensitive is. I think what sensitive is contextual, depending on the circumstances. There's a lot of guidance from the Privacy Commissioner on that. I don't think it would hurt to have criteria, but I think the courts are well suited to figuring that one out.
So I would ask if you could submit specific wording to the clerk on any of these definitions, and I'll get them to you before you go again, but it's on reasonable person, legitimate business interests, appropriate purposes, and appropriate circumstances for data collection. If you have that, you could submit that. It helps with our amendments to the bill, sir. Something else, we believe on the Conservative side that there needs to be a balance protecting Canadians' fundamental right to privacy with ensuring the ability of businesses to use data for good. Do you feel that Bill C-27 as written achieves that balance?
Thank you for that follow-up question. So I have reviewed the amendments proposed by the minister, which makes it clear that the joint purposes of the Act are the protection of the fundamental rights of privacy and the legitimate interests of business. I think that that's an appropriate way to do it. I think one has to understand that every fundamental right, including the fundamental rights in the Charter, are subject to the Oakes test, which is a balancing exercise, and that the purposes clause that makes it clear that we have a balance of a fundamental right as well as the interest of business gives the courts the appropriate tools in order to solve the problem. I'll also point out that the appropriate purposes section is basically an override section, and if there's something that an organization does that frankly is offside, that trumps everything. And so when you put together the purposes that's going to be in the Act with the appropriate purposes, I think the public is adequately protected. I won't get into also the fact that the Privacy Commissioner has huge discretionary powers as to how to enforce it with very limited rights to appeal. So if the Privacy Commissioner believes that a fundamental right has been violated and it's an inappropriate purpose, the Privacy Commissioner has all the powers that are required to do the proper calibration to protect the public.
Thank you, sir. Ms. Denham, the GDPR has been criticized for imposing high cost of compliance on small businesses. Do you feel that C-27 creates a burden for small businesses to comply with the data protection and filing obligations?
Well, I've heard that criticism about the GDPR and being burdensome on small businesses. I think organizations like the EU, data protection supervisors, the Information Commissioner's Office in the UK have really focused on small businesses and innovators to help them with their compliance. And it's not, I suppose there isn't such a strict category that we can draw between small business and medium-sized business in terms of harms that they could create. Just to remind you that Cambridge Analytica was a small business. And so therefore, I think what is more appropriately in context is the sensitivity and the amount of data that's being processed, whether it's two people working in their garage or a small political consultancy. There's many larger companies that aren't processing sensitive personal data. So I think really the point is to be able to delineate the potential harms and risks that a business is creating for Canadians and make sure that those risks are properly mitigated.
There are two sections, Ms. Denham, of the GDPR that C-27 copied, but ended up with a copy that strangely looks like AI generated. That would be sensitive information and legitimate interest exemption. In the GDPR, legitimate interest is meant to be a rare exception, but not normally as it is in C-27. The GDPR is a legitimate interest analysis which must be submitted and approved. Do we need to reform C-27 to better copy the GDPR?
Yes, I believe so. It's not that the legitimate interest is one of 6 legal bases that a company can use to process personal information, others being required by contract, informed consent, binding corporate rules, public tasks. So there's many legitimate bases for processing personal information. Legitimate interest is not meant to be an exception. It's one type of legal basis for collecting and processing data. And I think what's happened in C-27...
Monsieur le Président, je dois vous arrêter. Je dois arrêter. On signale que le son est de mauvaise qualité.
Oui, je viens d'entendre Monsieur Lemire. En effet, il semblerait que le son soit pas suffisamment bon. Madame Denham, is it possible to maybe move your mic up a little bit, the boom of your microphone, and say a few words so we can see with the technical
staff? Is that better? Can you hear me now?
On signale que non.
Well, in that case, maybe just one second.
I'm just consulting with the technical staff. Perhaps you could try again, Ms. Denham? Perhaps say a few words?
Yes, I was discussing the various legal bases for processing personal information. Can you hear me now?
Okay, just 1 second, colleagues.
Respond to the question from Mr. Williams on legitimate interest?
I think that would be a good use of our committee's time. Mr. Suckman, you can go.
So thank you very much for that question, because I have concerns about legitimate interest as well. As to whether it is weaker or stronger than the GDPR, it is substantially weaker than the GDPR as its wording. The GDPR, like the CPPA proposal, has a balancing. It is no free get-out-of-jail card. There must be a balance, and the use must be appropriate, and it can't adversely affect individuals. But unlike the GDPR, it doesn't apply to disclosures, which is very, very significant because it will impact, for example, search engine and AI companies are either not going to be able to operate in this country without an amendment, or they'll operate and they won't be subject to the law. And so the section needs to be fixed. The other thing, too, is it has additional tests that aren't in the GDPR about a reasonable person would have to expect the collection of such activity. That is tethered, Mr. Williams, to an old technology, a known technology, rather than a technologically neutral approach. We want something that's going to work in the future, and this language doesn't work. So I think the problem is actually the opposite of what you're asking for. We need to fix it so it works properly, but still protects the public.
Thank you very much, Mr. Suckman. Mr. Williams, I'll now turn it over to MP Gair.
Great. Thank you, Chair, and thank you to all the witnesses for making time for the committee and appearing in person and virtually. My questions are for Ms. Denham. So your expertise is very comparative, so I wanted to ask those sorts of questions. My first question is, you mentioned the Global South in your opening testimony, and that you're familiar with the privacy regime in the Global South. Is there anything that we can learn from the Global South in how their privacy regime is levied?
Yes, I hope you can hear me now. I hope the committee can hear me now. Maybe give me a thumbs up if you can.
It seems to be working with the interpreters.
Seems to be working. My experience with countries in the Global South is, if you take Africa, for example, and South America, a lot of those nations are not copying and pasting the GDPR, but they're certainly taking inspiration from the GDPR. And so I do think the GDPR is a global standard. There are different cultures and different legal systems, which means that it's not going to look the same as the GDPR, but certainly the principles do, and the respect and the need for privacy and data protection to be a fundamental right. The Middle East is different again. I was recently in Dubai, and there I met with the Minister for AI and talked to many businesses in the Middle East about their approach to data protection, transporter data flows. And it certainly is innovation forward, and I think is taking a different track than what I see happening in the global south. India's law is also being amended and reformed and passed, and that's a very exciting time to see what's happening in that country.
Great, thank you. So you also mentioned enforcement power and sanctions. What sorts of enforcement power and sanctions would you like to see?
I think that fines are important, and there's a lot of focus in this legislation on providing the commissioner with fining power. But I think fines are so 20th century. And although you do need to have fines available, I think, for the worst cases and bad actors that continue to contravene the legislation, what's more impactful and where I see more modern tools are things like stop processing orders or disgorgement of data, which means that a company can no longer use its algorithmic models, that it has to destroy data that was fed into a model because it was collected illegally. And we see the Federal Trade Commission in the US using these kinds of powers. You see that happening in Europe and the UK. Because at the end of the day, what is most impactful for significant contraventions of the law are those that actually impact a business model and not a fine that is just the cost of doing business. So I think there's a rethink that's needed to give the commissioner modern tools. And I look at fines as a last resort.
Great. So in meetings past, we've heard folks speak on both sides of the issue of the Personal Information and Data Protection Tribunal rather than the Privacy Commissioner directly imposing fines. You spoke about that briefly in your opening testimony. If you don't like that structure, what kind of a structure would you rather have?
Well, as I said, in the UK, there is a tribunal system, and administrative tribunals are used across many areas of law. In the UK, when it comes to freedom of information, data protection, cybersecurity, electronic marketing, all of those areas that the commissioner is responsible for, the decisions of the commissioner, fines, sanctions, are subject to a review by the first tier tribunal. Then the case can actually go to appeal to the second tier tribunal and then on to the court. So that sounds like what could be a very lengthy process. However, I think over time, the tribunals have become expert tribunals. And so you're not taking a very specialist policy area like data protection and having a general court look at the issues. So I think there are pluses and minuses. Obviously, the government wants to make sure there's administrative fairness, that there is an appeal system, because otherwise you have too much power concentrated in a government body. So you could understand why there should be appeals. But my argument is, if there is going to be a tribunal, then the standard of review needs to be reasonableness, like it is in British Columbia. And also, the members of the tribunal need to be independent and appointed that way. And thirdly, I think it's really, really important that the tribunal's not conducting an inquiry from scratch, because I think that undermines the commissioner's expertise. If no tribunal, then I agree with the privacy commissioner's recommendation that an appeal go directly to the Federal Court of Appeal rather than starting at the tribunal and then federal court.
I do love you. The structure of the adjudication of issues, where they start and how they get appealed, is a very, very important question. We have to recognize that with the importance of privacy and the amount at stake for the public and organizations, getting it right is really important. The powers of the Privacy Commissioner are very broad. There's really only anorexic protection procedurally, and yet the Privacy Commissioner makes the determination as to whether there's a breach and can make a recommendation as to whether there are penalties. The appeal goes to the tribunal, but the tribunal only has the power to order a reversal if it's an error of law. It has no power to do anything if it's a mixed question of fact or law or a question of fact. And when you look at the way the CPPA operates, there are going to be huge number, almost invariably, a huge number of questions of fact and law, which means effectively there's almost no procedural protection before the Privacy Commissioner, and any decisions are virtually unappealable. Also, the constitution of a tribunal doesn't require a judge, which is required in other contexts. So I do think there needs to be procedural protection in front of the Privacy Commissioner, and the appeal. You heard Ms. Denham talk about at least a reasonableness standard. That doesn't even exist before the tribunal. That would only exist on a further judicial review, but it's almost impossible to get there. So I do think this structure really needs to be changed to provide at least a modicum of procedural protection. Thank you.
Merci beaucoup, Monsieur Suckman.
Thank you very much, Mr. Suckman. You have the floor, Mr. Lemire. Thank you, Chair. Mr. Suckman, you recently shared your perspectives in an article on artificial intelligence, the regulation bill of the Chamber of Lords of the UK. You published it 3 days ago, if I'm not mistaken. And in your analysis, you highlighted the relevance of the British bill as a roadmap for improving the AIDA. And you talked about the parliamentary powers and the attention paid to the principles underlying AI. So what lessons can we draw from the British bill, and what principles do you think we should be incorporating within our act to strengthen AI in Canada and the regulations thereof?
Fantastic question. The private members bill that you referred to is also an attempt to have an agile mechanism for regulation of AI. And there are two things about that bill that I think are fundamentally important. And if this committee is going to make recommendations for improvements, there are two things that can be taken from that bill, and I would strongly recommend. First, the Secretary had the power to enact regulations in the first instance. But the regulations only become effective when they're passed by a resolution in both houses of Parliament. And for regulations that don't have that procedure, they can be annulled by either House of Parliament. That, in my mind, is a way to give effect to the important principle of parliamentary sovereignty. And that way, the government can go ahead with their regulatory analysis, but at the end of the day, they're still regulated by a mechanism of Parliament. I think that's a brilliant approach of solving the problem of parliamentary sovereignty. The second thing about the AI, the draft AI bill that I think is really important is that it contains the principles for guiding the legislation. If you look at ADA, it doesn't define high impact, and it tells you nothing about what the principles should be that would guide regulation. And what this bill does is provide, I think, a good first look at what could be an approach. And it starts off with saying the principle should be fundamental AI ethical principles, like for responsible AI, like they should deliver safety, security, robustness, those sorts of things. Number two, any business that's going to engage in AI, in this case I would say a high-impact system, should test it thoroughly and should be transparent about its testing. Third, it's got to comply with equalities legislation, that is discrimination, right, which is extremely, extremely important. And then lastly, and this is completely missing again in our bill, a consideration has to be that the regulation benefits outweigh the burdens. And then secondly, that the burdens of the restriction don't prejudice and would enhance international competition of the UK. I think having a set of principles like that to guide the regulatory framework would be very useful. When I saw that bill, I thought, this is genius. And this is from a private member.
Madame Denham, j'ai envie de vous laisser.
Ms. Denham, I would like to hear your comments. It's a UK bill. Do you also find that it's a wonderful one?
That's a private member's bill, as my colleague has just said. So I haven't studied that. The government's process right now, the government's direction is not to regulate AI, but rather to give existing regulators the powers that they need, including running sandboxes to beta test generative AI applications, machine learning applications. So what the government has said, yes, there's a set of principles, but the UK has stated, the government of the day has said that we're not going to regulate a specific technology at this point. Instead, they're creating an AI institute to have a look over all digital regulation and to encourage digital regulators to work together. So, and that is in contrast to the EU, which, as you know, it's in trilogue right now, but the EU has an AI Act that is comprehensive and reads like a product safety statute. So there may be a brilliant private members bill, but the government's preference is to really support existing regulators when it comes to this new technology and take a wait-and-see approach.
J'étais chez vous, Madame Denham.
I was where you are a while ago to participate in the Summit on Security and AI. And what lessons has England learned from the summit that took place in, let's say, a few weeks ago?
Yeah, the summit the global summit that was sponsored by the Prime Minister and the UK, I think that was really important because there was an outcome, which was an agreement of leading nations around the world around the approach towards AI. So there was a declaration that came out of that meeting, and it included China. And I think that is quite astonishing to a lot of people. But you see, ultimately, I think what we're going to need is an international solution in the same way that we regulate civil aviation around the world. I can see that we do need a world where we are regulating AI, at least to a high level of principles and standards. So I think that's what the British meeting from a few weeks ago, I think that's what was achieved, and dialogue is a good thing.
Effectivement, puis la Chine.
Yes, indeed. And yes, the fact that China signed it was surprising to me because of human rights in artificial intelligence. We'll come back to that. Thank you. Mr. Massey, you have the floor.
Chair, I'll start with Mr. Suckman, who's here, and then I'll go to our two virtual witnesses. With regards to the process, one of the things that's been difficult is that we still don't have some of the amendments that was brought up at the beginning of the meeting here. So, Mr. Suckman, I'm just kind of curious in terms of when you were preparing to come here today, how well can you be prepared for testimony on the full bill itself, and whether or not is your opinion, will you later on submit more documents or information later on, or will the committee actually have to circle around again to our original witnesses? Because we've tried to compartmentalize these things the best that we can. In fact, we split the bill for voting purposes into two sections, but it still is one bill here. So just curious as a witness coming here into the process that we've kind of engaged in, tell us what you think, and then second of all, what are we going to have to do once we get the other part of the bill in front of us?
Mr. Mast, thank you very much for that question, and I don't envy the predicament you're in. And in fact, the predicament you're in is a microcosm of the whole public in this who's interested in the regulation of artificial intelligence. It was quite clear from the minister's statement that there were amendments. We haven't seen the amendments on ADA, and all we have right now is the letter of the minister, which describes in very amorphous, open-ended form what the first focus of the government's going to be. But it's quite clear there's no definition of what the factors are for what will be high impact, and there's no criteria for future systems. So the reality is that we have still no idea. What really, really concerns me is that at the last minute, and even if it's next week, we're going to get draft amendments. And those amendments are probably only going to be half of the amendments because they're probably only going to relate to the pieces that were in the minister's letter. And everything else is going to be, I think, saved to clause by clause. When you look at the work that's gone around the world on trying to come up with an appropriate regulatory framework, this has taken years. The British have really studied this issue and, as Ms. Denham said, had taken the view that what's needed is a hub-and-spoke, decentralized regulatory framework. We're going to get, or the committee may get, amendments, and you're going to get a couple of weeks to review something that should have taken a year or years to be able to evaluate. Also, we're in the process of still finding out what the Europeans are doing, exactly what the U.S. Congress is going to do. We are making a big mistake, I believe, if we think that we can get dropped amendments, do a thorough analysis of them, and make policy for the country that's going to affect jobs, the protection of the public, and innovation for decades. So in my view, whatever comes out is not going to give this committee enough time to study it. And my strong recommendation would be to step back. The government's already said it's going to take 2 years to do the regulations. They can not go ahead with this part, do the study, introduce a proper bill. We won't lose any time, but we'll get something that's thought through and debated by the public and Parliament.
I'm glad you mentioned Ms. Denham. I do want to move on to a question for her. You did mention a little bit about where Canada's privacy record is in the world, and I was glad to hear you mention Ms. Stoddart. I mean, she really set the standard in many respects for a lot of different things that we saw. Can you give us a little more details on how we can reclaim where we're at with regards to our international reputation on privacy and protection for workers? I always thought this was an advantage for investment in Canada as well. I know that some businesses are a little concerned with some of the things that are potential in this, but at the same time, if we have clear, transparent rules that are consistent, it could be a benefit. So please, could you give us a little roadmap on how we get back?
Yeah. Thank you for that question. And yes, Jennifer Stoddart is a personal hero of mine, and I work closely with her in Ottawa as her assistant commissioner. One of the benefits of Canada is that Canada has been very a hardworking member of the OECD. So Jennifer Stoddart was the chair of the Privacy and Security Committee of the OECD for many years. And I think she was very influential in that role in bringing various members of the OECD and others around the world. And as a Canadian working in the UK, I was able to chair the Global Privacy Assembly, which is the group that brings together 135 privacy authorities around the world. And again, that was an influential post because it took me to G7 meetings and meeting with the ministers of industry and technology and trade. So really the privacy commissioners can fulfill a really important diplomatic and bridge building role around the world. And we've got, a great example, I think, in our current privacy commissioner. He's very well regarded already in international circles, but I think the investment has to go to influence other places and countries around the world, and the fact that data knows no borders and we're all dealing with the same big companies. There needs to be some collaboration and cooperation, and I can see that Canada can continue to play that role, but not when our laws are so 20th century. And, I think the update of the laws is so important, because the privacy commissioners in Canada, it's not sustainable to have ombudsmen and recommendation-only powers when data is the greatest asset of the 21st century.
I know I'm out of time, but I'll come back to you, Ms. Thomason, later on, so you're not left out. Thank you, Mr. Chair. I'll come back to you at my second round, Ms. Thomason. Thank you.
Merci, Monsieur Massé. Monsieur Généreux.
Thank you, Mr. Massé. Monsieur Généreux. Thank you, Mr. Chair. Thank you to the witnesses, Mr. Suckman. I have the feeling that we're going backwards here, hearing your comments. We heard those comments a number of times. We've heard them a number of times throughout the study, but did you find anything positive or interesting that should be kept here with regard to what is in ADA so far? That's my first question. My second question is about the tribunal. You mentioned it, or the courts. You mentioned them earlier. So we've heard some opinions on that issue as well. Some people think that there should be a tribunal established within the Act. So I'd like your opinion on that. And Ms. Denham, I'll ask all of my questions right up front, and then you'll be able to answer. Ms. Denham, the conference that took place in the UK a few weeks ago, a certain consensus was reached, namely that there should be a voluntary code. So if it is voluntary, would that replace some bills in certain countries? And does that mean that some countries will take a step back with regard to things that they've already set up or are setting up to use the voluntary code instead? Mr. Suckman, please, go ahead.
For those questions. So when I looked at the minister's letter, which provides some guidance, what I was very pleased to see are the new areas that are proposed to be regulated. We don't know how they're going to be regulated, but there was a proposal to add in dealing with discrimination in the courts and administrative tribunals, and I think that's very important. There was also something about introducing some guardrails in the criminal investigations, that is how police officers can do investigations that might be discriminatory. So those sorts of public things are very important. There was also something about regulation of services. And again, we have no idea whether this is intended to be public or private, but the EU has proposed to ensure non-discrimination on emergency services, for example, which is very, very important. But what we didn't see, and this is a problem, is that all the authority is still in the minister. When you look at what is proposed in the letter, you have various areas that are intended to be regulated. You have courts, peace officers, human rights, content moderation, which should be the purview of the justice minister. You have issues related to employment, which should be the purview of the labor minister. You have issue related to health regulation. That should be, again, within the Department of Health. I could go on and on and on, but I think one thing that could be done would be to give numerous ministers the power to make regulations in their areas, and that would help make this decentralized. I know I'm out of time, so I won't get to the tribunal question.
Yeah, okay. I want to make sure that Madame Dunham can respond to my question, please.
Yes, your question was about the outcome of Bletchley Park and the AI Safety Summit that was held several weeks ago. I think, first of all, the fact that there was an international declaration on the risks that AI, generative AI, brings to society. So there was an agreement signed by 25 countries, including China. And the second piece, though, was an agreement to agree on a multilateral agreement. So when you say it's a voluntary agreement, right now it is. But I think a multilateral agreement on how to test high-risk AI systems is a step in the right direction. But it absolutely is voluntary at this point. And, I think what we're seeing a very fast-moving regulatory environment that's trying to sprint to keep up with the technology.
Est-ce que vous croyez sincèrement, je vais parler à Mme Thomason?
My next question is for Ms. Thomason. What do you think of the answers that we've had so far regarding the bill? It's a very general question, I know, but I think it's important for all witnesses to have the opportunity to give their general opinion on the bill. Because we know that things have been separated out and not all in the same act. What do you think?
Yes, thank you. Well, you had asked about any positive aspects of the bill, and we did emphasize in our written submissions some aspects of the bill that we think are very commendable. Dealing with discriminatory bias is important. The recognition that psychological harm is an aspect of harm is important and commendable. And taking a regulatory approach to give clarity to how AI systems can be operated and what obligations and transparency requirements exist for companies using AI, I think is all very important. The companion document that accompanies the legislation contains a lot of, I think, very important points as well and perspectives, which we don't see reflected in the legislation itself, the draft legislation itself, which we noted in our submission is, is a missed opportunity. There's a discussion about collective rights in the companion document that is crucial when we're talking about AI systems because of the way these systems work on large quantities of data that draw out inferences based on an assessment of a large group of people. The idea that harm can be actually materialized at the collective level rather than solely at the personal level is something that the law needs to acknowledge. And this would be relatively new for our law. It's not brand new. There are areas of law that recognize collective rights, of course, but it's something that we're going to have to see recognized more and more. And I think that exists in the companion document, and that should be integrated into this bill if it's going to go forward. I would just say very generally, though, I think a lot of what we're talking about highlights that we actually need to step back when we think about AI regulation in Canada. IDA did not benefit from the consultation. I think that would have been useful in advance of its drafting. It could take a much more holistic approach. Mr. Suckman has highlighted some of this. Ms. Denham has highlighted some of this. There are many considerations that have to go into how we would establish a framework for regulating AI in Canada that we don't see here and that I think is going to be difficult to integrate solely through textual amendments to what we have in front of us.
Thank you. Merci beaucoup.
Thank you. MP Van Bynen, the floor is yours.
Thank you, Mr. Chair. I'd like to go back to Ms. Denham and take advantage of her international experience. The Bill C-27 creates new Artificial Intelligence Data Act, which appears to be based on at least part of the European Union's Artificial Intelligence Act, which also proposes a risk-based framework for artificial intelligence systems. How do you compare those two pieces of legislation?
Well, the EU AI Act is a comprehensive, in terms of its scope, it's a comprehensive act, so it applies to the public sector, it applies to the third sector, it applies to the private sector. It's a product safety statute. So it doesn't give individuals any rights, but what it does require is it requires companies to categorize the AI systems that they are procuring or they are developing. So it has to be slotted into one of the risks. There's prohibited AI, there's high risk AI, there's low risk AI. So it's up to the companies to be able to actually determine the risk that they're creating for others. And then according to that risk, there's due diligence and accountability and transparency and oversight that is really tied to the level of risk. And just to give you an example, there's a group of prohibited AI uses, and one of them is live facial recognition technology used by police in public spaces. So the EU has already decided that's prohibited. There's many other sort of low risk chat box, for example, that may be considered a low risk AI or algorithmic risk. And what companies need to do and what governments need to do is prove that they've got a comprehensive data governance, AI governance program in place, an inventory of all the AI systems that are in use, and stand ready to demonstrate that to AI regulators across the EU. And so I think, what the EU has is first mover advantage in terms of a comprehensive AI law. That's what it has. But that doesn't mean the rest of the world is going to copy and paste that approach. That said, any company that is outside of the EU that is directing services to citizens, to organizations in the EU, will be subject to the EU law. So that means that the world is paying attention to what the EU is doing in the same way they did with the GDPR. So first mover advantage there. I think what the US is doing is extremely interesting because it's difficult to get anything through Congress these days. We know that. But instead, there is an executive order on AI, which really requires all government agencies, all supply chains, all procurement in every single agency, be it Health and Human Services or Department of Defense. They are required to comply with AI principles, and they also have to stand ready to demonstrate that they're being responsible. And I think that is going to be hugely influential, but quite different in the approach that the EU is taking.
The aspect that you'd raised earlier is with respect to the teeth in and enforcement in violations of some of the statutes. And I was particularly interested in your reference to the stop processing order and the discouragement of data order. If I recall correctly, there was recently a $1.2 billion fine, which seemed to be heralded as a huge fine. But for an organization that was the violator, that could simply be a consideration of a cost of doing business.
It could be a rounding error.
In some cases. Could you expand a little more on those two concepts, the stop processing order and the discouragement of data order? Because I think these are elements that need to be considered seriously to give the regulators the effect that they need to have to deal with these global enterprises.
Right, and I can't recall at this moment whether the CCPA has a power in there for the commissioner to order deletion of data that maybe have been gathered illegally or not properly consented to. So I can't remember if the commissioner has that power, but it is certainly something that is necessary, I think, in the modern world, and could be much more effective in changing business practices rather than fining, a large data platform, a social media platform, hundreds of millions of dollars. So if the data is collected illegally, if the data is used in a significant contravention of the Act, then requiring a company to delete that data has an enormous effect. And, I think of a case that I had when I was the commissioner in the UK, and that was that one of the government departments had illegally collected biometric data of claimants, and they had to give their voice prints, which is a biometric data, which is sensitive information under the GDPR. And the order was that they had to delete all of that data and basically start over again. And I think that was more significant, and actually among peer departments in the government, that lesson was learned really quickly. So rather than fine the government department, you say you collected this data illegally and it must be destroyed. And you'll see the Federal Trade Commission has acted in several cases around data deletion and data disgorgement. And, at the end of the day, what companies want is sustainable business practices. And they want assurance that they're doing the right thing. And really, that's the lens through which we should be looking in Canada at the powers of the Privacy Commissioner, for example.
And I've run over time. I'm wondering if you could send us some examples of that for consideration and review. Thank you.
Absolutely.
Yes. Go ahead, Mr. Sukman.
If you look at Section 93(2) of the CPPA, the Commissioner has very broad powers to order compliance with the Act, including to take measures to comply with the Act, stop doing something that's in contravention of this Act, and so forth. So if there's an entity that is in contravention, the Commissioner has the right to effectively get an injunction and have that injunction enforced by the court. And that would include if an entity has data that should not have been collected properly, then that could invoke the data deletion requirement. So I believe that the Commissioner will have those powers.
Merci beaucoup, Monsieur Sukman.
Thank you very much, Mr. Sukman. Mr. Lemire. Thank you, Mr. Chair. Mr. Sukman, during the AI Summit, our audience on AI, you had a panel that was on wisdom and experience in intellectual property with regard to AI. I was wondering whether you could tell us a bit more about that. What are the concerns that we should have with regard to protecting copyright, not only in a cultural context but also in research, and what the problems are with C27 when it comes to protecting those property rights? Because we know that Canada has an act that is no longer modern and has difficulty protecting copyright in general. Will C27 help us?
For that very important question, the draft law that's in front of you doesn't deal with intellectual property rights at all. And that's unlike the EU legislation that has at least a provision requiring transparency in data that's disclosed. It's also unlike the draft UK bill that require compliance with copyright laws, and it's also not consistent with draft French legislation, which would also require compliance with copyright laws for training models. As you know, there is a consultation ongoing with ISED and the Department of Heritage that asks a number of questions, including whether the Act needs to be changed, and in particular whether there should be a new text and data mining exemption. That is a very, very important consultation and raises the balance between the ability of creators, including many creators from Quebec, to be able to control the uses of the work and to get compensation for the uses of the work when their models are trained, versus what might be an interest that AI entrepreneurs have and larger businesses to use works for training the models. So it's it's a question that has policy considerations in it. In my view, the existing law adequately sets the standard, because while training models would involve the reproduction right, which would be prima facie infringement. There's also subject to a fair dealing exception. And fair dealing is the best way to calibrate, using the current law and the current principles, the use of works without consent.
Si vous voulez, vous pouvez poser une autre question, Monsieur le Maire.
If I may, I'd like to ask another question. Yes? Oh, okay. Thank you. Mr. Massey?
Thank you, Mr. Chair. To Ms. Thomason, you mentioned in your original submission to us that special attention needs to be taken place, and also to separate the policy. I had the chance to attend in the United States this summer a couple of different conferences that was put on by Amazon, Google, and Meta, and a few others that were lobbying at the national state legislature level. And one of the more interesting aspects was that we seem to be, as they're developing their own AI, in their hands of them trying to come to grips with the imbalances and the biases that they have, because the people that are contributing to the AI are not reflective of society. So maybe you can kind of highlight that a little bit with regards to, I think, maybe some of the concerns that you have in terms of how we're allowing currently right now some models of AI to go forward with very little balance in many respects for societal issues related to gender, race, ethnicity, and so forth.
Yeah, thank you. That's an excellent question. I think my first reaction would be that this goes back to an important need for this bill to really be able to allow for regulations that will address discriminatory biased outputs that come from AI systems. If the bill is structured in a way that that obligation is clear and actually captures the range of ways in which algorithmic bias can arise, then companies will have an impetus to hire teams that are better enabled to anticipate and mitigate some of those harms. One of the comments that I included in my introduction was that one of the issues, and what I see as one of the limits of this bill as it's structured right now, is that many occasions of discriminatory bias have been identified after the fact, usually through investigative reporting, usually by experts or people who experience these harms themselves and so have an understanding of the kind of harm that might arise. And then when that becomes publicly known and there's a public backlash, at that point, there's an explanation that it was unforeseeable at the time that the system was being developed, or that the initial idea was developed to automate a decision-making process that was previously done by people, for example. So I think this bill, in the structure that it's in right now, needs to be enabled to capture not just discrimination on recognized grounds, but also discrimination by proxy for a recognized ground. So where postal code might stand in, or where employment status or previous experience of imprisonment, or social networks, where those might stand in to influence algorithmic decision making and reflect protected grounds. This bill needs to really capture all that complexity of how these harms can arise, so that companies are then motivated to ensure that that kind of discrimination doesn't happen to the best of their abilities. This is also why we recommended an equity audit, which obviously would need more structure, probably in regulation, to really signal in advance the importance of equity and anti-discrimination in the development of these systems. It's a crucially important point. I honestly do think that the companion document reflects the importance of that, but we don't see it fleshed out in the bill right now.
Thank you. Could I add just a very quick supplemental to that? Mr. Mass, the question you ask is very important, but we need to recognize that one of the reasons there's the discrimination in algorithms is because they're being trained on data that is currently being used in other contexts. And so I think we need to recognize that this problem is not just an algorithmic problem. It's a problem with discrimination we have in this country that's not being addressed. What's the best entity to deal with that? It's the Canadian Human Rights Commission. And I think we don't need to solve this problem with ADA. There's ample authority under the Canadian Human Rights Act to make extensive regulations. They need to be given the power to deal with all discrimination that's currently not covered, including algorithmic. Put the expertise in them, not in not separate them so that the Human Rights Commission is dealing only with older discrimination, but not algorithmic discrimination. Let them deal with this so they can take a holistic view and solve the problem and deal with the problem.
Oh, and I'll just wrap up real quick. But what I saw was extremely, and I appreciate that, and disturbing, because right now all the AI that's being launched is being launched under the so-called generosity of the company's own interpretations of what they believe is fair and their hiring practices of what they're trying to do for their models that they're launching. So the human rights thing I take to note as well, too. And thank you for the online witness as well, too. Thank you, Mr. Chair.
Thank you. Mr. Viss, the floor is yours.
Thank you, Mr. Chair, and thank you to all of the witnesses here today. Recently, the Chief Information Officer of Canada, Catherine Luello, resigned from her position. Recently, she made comments that the public service needs to build credibility in respect to a fractured IT system with up to 2/3 of government departments being poor at managing information technology systems. Mr. Suckman, in that context, do you think it is responsible for us as legislators to allow the AI bill to go forward?
So, Mr. Williams, thank you for the. Oh, sorry, Mr. Justice. I'm sorry. Thank you for the question. I'm not familiar with that, and I don't know that it provides any insight into whether this bill would be adequate because there isn't proper management of IT. However, to the extent that there's a requirement for expertise related to the regulation of AI. That expertise doesn't currently exist, in my view, within ISED. This is very, very complex, and if you can't manage an IT system, how are you going to manage an AI ecosystem? If that's your point, I agree with you.
Yeah, that came directly from the recent Auditor General report, which basically outlined that the government's failing Canadians as it relates to the management of data that the Government of Canada collects on all of our behalf. Ms. Denham, thank you for your testimony as well. I was very interested in some of the work you've done in the UK, and I really believe that your testimony provides a lot of weight in respect to the amendments we need to make in respect to children. Prior to this meeting, I looked at the age-appropriate design, a code of practices for online services that came from the Information Commissioner's Office in the UK. In that document, it is outlined that there are 15 principles related to the protection of children's data. Those include the best interest of the child, data protection impact assessments, age-appropriate applications, transparency in respect to how companies are using data, I presume, the detrimental use of data, policy and community standards, default settings, data minimization, data sharing, geolocation, parental controls, profiling, nudge techniques, connected toys and devices, and other online tools. I presume, given your expertise, that you're somewhat familiar with the Code of Practices outlined in the United Kingdom, and which are also part of the Data Protection Act of 2018 and Section 123 of the UK bill. Given your expertise, would it be your recommendation that this committee adopt a similar code of practice to ensure that children across Canada are not subject to online harms? You're on mute.
Thank you for that question. And all the work that I've done as a regulator over 15 years, the work that I think is most impactful and the work that I'm most proud of is developing the age-appropriate design code. The code is a statutory code, which means that it's enforceable by the Commissioner and by the court. So it's not guidelines, and it falls directly from the UK GDPR. So the UK GDPR has some provisions in it that I would recommend need to be in the CCPA. And one of them needs to be a statement in the preamble or in the purpose statement that recognizes that companies need to provide services in the best interests of the child. And that language comes out of the UN Convention that I mentioned earlier, and Canada is a signatory to that. So the best interests of the child.
Thank you for that. I think on that point, please be assured that the Conservative Party will be putting forward an amendment, and hopefully the other parties will work with us to see a clause on the best interests of children put into this legislation. Just a point of clarification, my mic was off earlier. Did you write the code of practice, the code standards for children in the UK?
Yes, I did with my team. We were directed to write a code by Parliament. So it was a requirement in the Act. It was a one-line requirement to have an age-appropriate design code. My team worked for 2 years. We had 57 roundtables across all industry sectors. We worked with child psychologists and parents and children themselves, all the gaming industry, the social media, video sharing companies, and came up with the code. And the code has been deeply inspiring to many countries around the world.
Well, thank you. It's very deeply inspiring to me as a parent of 3 young children, and I know to many other parliamentarians across the political spectrum. In respect to the relationship between Parliament, the Privacy Commissioner in the UK, and the Design Code, does the Design Code and the legislation in the UK provide for flexibility to account for future technologies and future harms that children may face?
It does. So obviously the Commissioner's Office developed the code, but it was laid in Parliament. So Parliament approved the code, which gives it status before the courts that the code needs to be taken into consideration.
One final quick question. I'm so sorry to interrupt you. Do you believe that if we took a similar measure here, we would be doing about as the right thing to protect children in Canada, to give status of a code such as they have in the UK for Canadian children as well?
Yes, and I think because the CCPA gives the Commissioner a new power to create codes and certification, that there would be a vehicle in the CCPA for the Commissioner to develop such a code, as it's happening across Northern Europe and Argentina and Turkey and Ireland and many places around the world are really, state of California has this code.
Merci beaucoup, Monsieur Vice. C'est tout le temps que vous aviez. Je passerai la parole.
Thank you very much. Ms. Lapointe, you have the floor. Thank you.
The LEAF organization submitted a brief to this committee in September. And can you expand on your recommendation to amend Section 5 by adding language of identifiable group, collectively owned, and group collective? And as you explain that amendment, can you also tell us why it is important?
Absolutely. Thank you for the question, and I'm happy to explain that. So, the exact wording, of course, we would leave to the discretion of the expert lawmakers who are working on this and to your esteemed committee who's working on potentially proposed amendments. The reason we incorporated that wording into Section 5 was to respond to the ways in which harm can be experienced at the collective level and not solely at the individual level. So the law has traditionally recognized individual harm. So like if I'm, injured physically, psychologically, or I lose money, that has been more the traditional focus of the law. But as I mentioned in an earlier response, the law is going to have to start to recognize and acknowledge the ways that harm can be experienced by the group and that harm affects us as individuals as well. And so our wording is meant to provide a suggestion for how that could be incorporated here. And the reason that we incorporate that, and you see it in some of the discussion that follows the suggestion, is because AI systems trained on large bodies of data are used to identify patterns and to draw out inferences that can affect folks based on the groups to which they are a member, even if it doesn't affect them directly as an individual. And to recognize that as a harm is significant because it allows the Act to actually capture some of the ways in which inequitable injury and losses from the growing and flourishing of this industry in Canada are going to be distributed within society. If there's time, I'm happy to give an example, but we have some examples of collective injuries in the written submissions as well, if that is easier.
Okay. I'd also be interested in hearing how you would see the implementation of those amendments. How can that be done in an effective way?
Yeah, so Here's where there's a little bit of a struggle, and part of the reason going back to the recommendation that actually it would be preferable to revisit this act altogether. So I'll point to that first, and then I'll speak to the practicalities. I think a part of the challenge here is that it seems that one of the federal heads of power that was used to develop this act is the criminal law head of power. And so there's a tension between a criminal law penalty, which should only arise at a high threshold, and the need to actually acknowledge and mitigate as many harms from AI as possible, especially if we want to see this industry actually flourish and bring benefits to Canada. And so I would just acknowledge that that tension exists and that is something more complex to resolve. But in the structure that we have right now, how we would see that actually play out individually or in practice would be through greater refinement and instruction from the regulations and from the minister going forward. And again, with acknowledging the critique of that structure. But there would have to be, along the lines of how the Privacy Commissioner provides guidance to businesses on how to meet certain criteria. I think that this would be an area where education, norm setting would be absolutely crucial. But I do think, bottom line, it is imperative that this act not overlook collective and group level harm if it is going to actually mitigate the harms that we're going to see as the AI industry grows and becomes more widespread.
And what recommendations could you provide to this committee on how AI legislation can or should be protective of equality and human rights when it comes to private companies using AI in public spaces?
It's a fantastic question. A human rights approach, as opposed to a risk mitigation approach, would be something structured more like the Charter or like the Human Rights Acts, where we identify values that are important, that need to be prioritized, and that should not be violated. And that when they are, there's a structure in place to seek accountability and in particular to seek compensation. So I think that would actually be a stepping back from this approach to legislation altogether and a revisiting of what is it that we think is crucial as we support the growth of the AI industry in Canada. This bill is structured as a risk mitigation approach. So within that confine, we are stuck with how do we identify risks and avoid them as much as possible. And I think both of these need to go hand in hand. I'm not saying that we shouldn't have risk mitigation. Risk mitigation already exists in a lot of our laws of general application, like negligence and product liability. So some of these obligations on companies to think ahead to what kind of harms might materialize, those already exist. So how can we provide greater clarity to companies that want to utilize AI so that they can better identify particular risks that are especially likely to be dangerous that could arise from the use of artificial intelligence? So if we're going to maintain a risk mitigation structure, our recommendations have been that we need to then expand our understanding of the risks that are pertinent, and ideally also accompany that with government support for companies to better develop equity audits, to have expertise in-house that can aid them. And I would just say all of this also benefits companies and industry that exists right now in Canada. I mean, companies that are going to lose out from recommender algorithms sending you to Amazon instead of to a small business, those companies are also, I think, probably very concerned about how we structure our AI regulations. So I think that this whole conversation fits with, we need to step back and think through this from a different lens.
Merci beaucoup, Madame Lapointe.
Thank you very much, Madame Lapointe.
So I'd ask him to regain his seat. Mr. Vice Chair, the floor is yours.
Yes, at least I was still in the room. Thank you, Mr. Chair. My question is for Mr. Sookman, and the testimony of all the witnesses have been, like pretty much every meeting of this, fascinating. And I think the questions from all the members have been amazing and drawing out some really good stuff. I am, even though we're sort of talking about privacy, I don't want to lose the opportunity to ask you a question or two about ADA. You spoke a lot about ADA. I've been thinking a bit about this, but are there some guiding principles that should be included beyond just the classification of the various types of artificial intelligence, but there should be some public policy guiding principles. And if so, do you have any thoughts on what they might be?
Yes, thank you very much, Mr. Perkins. I think that one of the real failings of Ada is there is no guiding principles. And the guiding principles are important because they will influence the regulation, and they will influence where there's enforcement, what those principles should be. I indicated in a previous answer that some of the guiding principles that could be a useful start were in that UK private members bill, where the member had given quite good consideration of various factors, which included responsible AI factors, the requirement for transparency and risk mitigation, as well as from an economic perspective, the need to be sure that regulations are proportionate to benefit versus burden, and also takes into account international competitiveness. That may not be, the be-all and the end-all, but the Act should, assuming this can be, somehow salvaged, there's some things that could be done. One of them are guiding principles, and I would suggest that that bill is worth considering.
One more quick question before I have to move on to another area. If you could, in just a brief amount, you suggested that in your remarks that the current drafting of the Ada bill could impede innovation, and obviously the British are focused quite a bit on trying to attract and be a center of artificial intelligence development. What could you expand on that a bit?
Thank you very much for the question. Ms. Denham talked about the European approach as being a first mover. In fact, there's starting to be a wisdom that while they're a first mover, they're no longer the right approach. And the concern is very much that not only is it not the right structure, but that it will impede innovation. And the UK is very much focused on that. The US executive AI order is very much focused on that. And the reality is that Canadians need access to these tools. And if there's impediments to that, that could set us back a lot. You have to recognize as well that if you have complicated regulations that aren't in place in other countries, it requires Canadian entrepreneurs to make investments that don't have to be made in order to compete in foreign markets. And, a lot of these companies are small companies. They don't have the resources to sit down with lawyers and figure out how to comply with something that is really difficult. We need to empower them. We need to be sure they're responsible with voluntary codes and to deal with the very high risk stuff in a thoughtful way. But we have to be sure we don't make a mistake in bogging down our entrepreneurs, have them move, as they've done in other areas, to the United States where they can start businesses, and we lose the income, we lose the people.
Thank you very much. Mr. Chair, on Friday I gave notice of a motion that I would like to table now, and I'll read it into the record now, that given that the clerk has invited Annette Vacherian twice to appear before the committee to discuss her conflict of interest at Sustainable Development Technology Canada, and that the witness has twice failed to provide a date of availability, the committee therefore summons Annette Vacherian to appear before the committee in person for a period of not less than 1 hour, no later than November 30th, 2023, and further that the committee requests Sustainable Development Technology Canada provide any declarations of conflict of interest from board members since 2015. And a brief explanation, as I understand that Ms. Vacherian is leaving the country on Friday, and as such, we've given her lots of chance to appear. We have a space, as she knows, available for on Thursday. She has the ability to appear on Thursday. I don't think we're going to get her to appear, so I would recommend that we summons her. Thank you.
Thank you, Mr. Perkins. I recognize Mr. Turnbull.
Thanks, Chair. So I wanted to speak to this because my understanding is that the original motion that we agreed to and I don't want to read it to members because I'm sure you all have a copy of it, but it specifically indicates that this committee would take testimony of witnesses who've appeared or testified before other committees, and it explicitly was part of the conversation that we had that Annette Verschuren, who was or is the former chair of the board at SDTC, had already appeared before ethics. So I'm not sure why Ms. Verschuren was actually invited to this committee, given the fact that we said that we would take that testimony as our own so as to avoid duplication at this committee. I would also direct people's attention to that motion did also say that the committee reserves the right to re-invite said witnesses as necessary. But my understanding is that no case has been made before this committee as to why that would be necessary. I have Ms. Verschuren's testimony here before the Ethics Committee, which I've reviewed, and it seems quite substantive. So I'm just abiding by the original conversation agreement that we had, in passing that motion. So I don't understand why we would need to summons a witness that no one has made a case for why we'd need to re-invite to this committee when we all agreed that we'd have her testimony as a part of this study at this committee. So those are my thoughts. So I'm not inclined to support a summons at this time.
Turnbull, and I'll recognize Mr. Massey, and then I have Mr. Perkins.
Yeah, thank you. I'll just be real quick so that, and apologies to our witnesses, but we've got to deal with some important business here. I was in one of the meetings for ethics, and a lot's changed since then. So I guess what I'm concerned about here is if this individual is leaving the country, and then I've had further contact by whistleblowers since that time. So a lot of things have moved on. And there's also been, I think, a process put in place for the workers, but there seems to be some issues with that. So for all those reasons, I'll support the motion if necessary. But nobody likes to have to do this. But if we have a witness that's going to leave the country, I don't know what else we do.
Just as a point of information for committee members, I've been informed by the clerk that the witness in question has mentioned that she would be available to appear on the 12th before this committee. So just something to keep in mind as you decide on this motion. Mr. Perkins.
Thank you. Yeah, the 12th is a little late on this, as it was put in as an emergency meeting, and to address Mr. MP Turnbull's point, and it's a legitimate question. There is a lot of other areas which you will find out later today and in subsequent meetings that as the chair, the current chair, and she is the chair till December 1st, so it is a governor and council appointment, that the chair has responsibility to answer for much broader than the narrow line of questions that were asked of the chair in the ethics committee meeting. There is a lot more information that's come to light. Perhaps the government isn't aware of it. That wouldn't surprise me. But there's a lot of other areas. I won't be duplicating what was raised in the ethics committee with Ms. Visharian. It's a whole new line of questioning.
And so I have Mr. Lemire.
Donc, Monsieur le Président, vous...
Mr. Chair or Madam Clerk, could you confirm to us that Ms. Verschuren will be here on the 12th, so we don't have to summons her through a motion? No, I just mentioned that she is available on the 12th. That's what she told the clerk. All right. Well, I'll keep thinking about it. Okay. Thank you.
Mr. Turnbull and then Mr. Perkins. And perhaps I'd also just highlight that Mr. Turnbull has pointed out quite clearly that in the original motion on this emergency study on SDTC, it wasn't necessarily clear like which witnesses were to be invited. So it's up for the committee to decide if it seemed necessary, as Mr. Turnbull has pointed out. So I'll yield the floor to you.
So, I mean, the committee hadn't had a deliberation on that. Thus, I don't understand a summons, given the fact that any invitation was actually premature because the committee hadn't deliberated on it at all. So I don't know why Ms. Verschuren was invited, but seeing as how it's sort of moot at this point, if she's available and has gotten back to the committee and said December 12th works, then why wouldn't the committee just take her up on that offer rather than summoning her, which is, I think, completely unnecessary at this point. So there's two good arguments there for, and then I would say, well, what's the argument for why members think that we need her to come to this committee when she's already testified at another committee? I don't really hear a good rationale for that from my perspective, but I would invite other members to provide that rationale. She's also, my understanding is that she's resigned from the board and the minister has accepted her resignation. Okay, well, so December 1st, if that's in effect as of December 1st, what can be gained? Anyway, I think that the point, that's sort of point, regardless of that, in terms of timeline, I think there's two arguments that I've made here for why this committee would have to justify even the invite itself to have her come and appear here, given the first motion that we all agreed to. So I'm just abiding by what the committee agreed to, and we haven't had a deliberation on why Ms. Verschuren should be invited. But I certainly would just say a summons does not seem necessary from any perspective that I can entertain.
Mr. Perkins?
So on MP Turnbull's latter item, to tell you the situation we're in, Ms. Verschuren refused to return any of the contacts from the committee until I tabled my notice of motion on a summons on Friday. It was after that that she decided to actually start communicating with the committee. Secondly, I will not share with you or any committee members at this stage the line of questioning that I need to do to the chair, who is the chair of this organization and is accountable through the estimates to this committee. I will not share with you or anyone else the line of questioning, but I can tell you it is not what is in, from my perspective, it is not what is the focus and the narrow focus that was followed by the ethics committee around the COVID funding and top-up. That was the main issue that they dealt with. It's much broader than that. So this will not be a duplication of anything that the ethics committee did.
Okay, just before I turn to Monsieur Lemire, I'd just like to say thank you to our witnesses. I think you, given the time and the nature of the discussion, we're not necessarily near a vote on this motion. So I just want to thank you for your testimony today and for sharing your insights with this committee on C27. And you are, if you feel free if you want to listen to this debate, but mais autrement vous êtes libre de quitter.
But otherwise, please feel free to leave the meeting. Thank you once again for having made yourselves available for the committee today. I would like to give the floor to Mr. Lemire now. Yes. Thank you, Mr. Suckman. Mr. Chair, the second part of the motion refers to a declaration of conflict of interest, and the Conservatives have this habit to make the same request at a number of committees. So I think that this particular one with regard to a declaration of conflict of interest would be more relevant for the Ethics Committee. Can I ask whether that question was asked to the Ethics Committee and what the Ethics Committee's response was?
Have that information, but Mr. Perkins, you want to intervene on that?
Yes, I've attended the Ethics Committee meetings on this. The issues of the tabling of formal conflict of interest documents, which you have to do as a director, was not an issue that was raised at Ethics Committee. It's not a document that the Ethics Committee has asked for.
Mr. Turnbull?
My understanding from reviewing the testimony from the Ethics Committee is that conversation about conflict of interest was a very large part of the questions that were asked to Ms. Verschuren when she appeared before the Ethics Committee. So my point is that was taken up at the Ethics Committee. It is a part of the testimony that she gave. I'm reading here questions from MP Green, between MP Green and Ms. Verschuren, and that pertains to conflict of interest and some of the board policies around that. So it is the case that it was taken up at the Ethics Committee. We also know that the Ethics Commissioner is doing an investigation. So, I mean, to me, I'm not sure, again, what the rationale is if that's the main concern.
Mr. Perkins?
Just on the second part, I'll just explain because clearly some of the members don't understand. There's a difference between a discussion in the Ethics Committee about conflict of interest in the investment committee process and board process of approving investments versus, and I'm sure MP Turnbull is very interested in this, versus the actual formal thing you have to do as a director on a corporation board, of which I've been both on Crown and private and publicly traded companies. You have to declare, it's a formal declaration on paper, of a conflict of interest of companies that you have an investment in. This is asking not for a debate on the conflict of interest, but those declarations, those forms that Crown Foundation has from directors and is accountable to this committee. It's just asking for those documents. It's not about the debate of conflict of interest.
Monsieur le Président, le mot convoqué.
Mr. Chair, the word summons is a heavy one, so I'd like to ask my Conservative colleague why he uses the word summons. Could we just invite the witness? Could we change the date to include the 12th of December because she has said that she's available there? Perhaps she wasn't available before, because there could be a number of parliamentary procedures that could be the result of a refusal to appear after a summons. And so is that what we want to do right now, given the fact that we have a potential date where the witness could appear? I think that changes the scenario a little bit and the approach that we should take at this time.
Mr. Perkins?
Thank you, MP Lemaire. The witness was already invited, and she was invited for this Thursday and is around this Thursday. She's in the country. She leaves on Friday. She was already invited and has refused to come. So she has said she's available. She hasn't said if she's coming on the 12th. And so, frankly, at this stage, given the lack of response and her refusal to even acknowledge an invitation by the committee until my Friday motion for the summons, which, yes, is a powerful tool, was tabled, all of a sudden she remembered that she had to phone back, or her assistant had to phone back and say, oh, maybe I should come now that you're going to use your power to summons a witness. So I just, at this stage, I'm not feeling comfortable that the witness proposed here is actually going to comply unless she's summoned.
Monsieur Turnbull.
Respectfully, I don't think we can confuse not responding with a refusal to appear before the committee. But I want to make the point that I made before. Those are two different, very different things. An email can get lost in an inbox. Someone can be unavailable. I think there could be a very reasonable explanation other than what Mr. Perkins is assuming, which is the most negative interpretation we could give. You know, being a little bit more charitable in our interpretation, she has now responded and said she's available on the 12th. So perhaps the word summons is not necessary. But I want to go back to the point that I made earlier, Chair, which is that Ms. Fisherin shouldn't have been invited at all until our committee deliberated on whether that witness was necessary. So what I'm asking for is, how did she get invited twice when the motion itself, the letter of that motion and the agreement that this committee made was not to invite witnesses, but to use their testimony and then deliberate on whether those witnesses needed to be re-invited to this committee. That's what the motion reads, Mr. Perkins. So don't tell me it doesn't. I have it right here and I can read it back to you on the record. I know you don't need that. You're a smart enough guy. But the point is that she shouldn't have been invited in the first place before this committee had had a conversation about it. So to then imply that she's somehow refusing to appear is not the case. It's just not true.
If I can just jump in on that, then I'll take some of the blame. The motion wasn't particularly specific about the list of witnesses in the text of the motion. I did. As a clerk to invite the witness, so I'll take the blame for that. But you're absolutely right that the text of the motion doesn't necessarily specify that the committee would invite that witness. It's a discussion that this committee should have. But I guess it's hard to have it now, given that there is a motion on the floor which needs to be voted on. That's also to some extent an opportunity to have that discussion whether we feel like it's necessary. I had some members come up to me and make the case that they felt we needed to invite that witness. So I did instruct the clerk to invite the witness. However, I didn't have the instruction from the committee. I'll grant you that, Mr. Turnbull, you're correct. But we still have that motion with the summons that Mr. Perkins has presented. Mr. Turnbull.
So, I mean, if we can all agree that a summons is not necessary, then perhaps we could agree to re-invite the witness for December 12th. I mean, to me, that's perfectly reasonable given the fact that we're all acknowledging, and the chair is acknowledging, that in essence, the witness shouldn't, following the letter of the actual, what was agreed to at committee, that motion didn't imply that witness needed to be re-invited without a deliberation of the committee.
Are there any more comments? Otherwise, we'll put the motion, Monsieur Lemire.
Dans l'esprit.
In the constructive spirit of this discussion, I was wondering whether my Conservative colleague would perhaps agree to reflect on changing the date to the 12th in the spirit of conciliation. That could perhaps create consensus around the table if that date were changed.
Donc, il y a une proposition de Monsieur Lemire.
So there's a proposal by Mr. Lemire, who's saying by the 12th. Yes, I understand. But what I'm hearing from the Conservatives is that it should be between now and the 12th. So that would give latitude to the clerk. So it would be no later than December 12th. That's the amendment.
On aurait besoin d'un amendement à la motion à ce moment.
So I think we need an amendment to the motion now. Is that agreeable, Mr. Turnbull?
Mr. Lemire has made an amendment to the motion itself, or not? No. So why don't I propose an amendment?
Go ahead, Mr. Turnbull.
So I'll propose an amendment that we change the word summons to re-invite, and that we change the date to no later than December 12th. I can read it in full if you want, but I think you get the gist.
There was an amendment moved by Mr. Turnbull. Are there any comments on the amendment, Mr. Perkins?
Just a quick comment. I would support, as Mr. Lemire said, moving it to the 12th, but I don't support removing the word summons.
Maybe we can, Mr. Chair, maybe we can ask Mr. Lemire. Peut-être on peut demander à Mr. Lemire de.
Perhaps we can ask Mr. Lemire to propose an amendment, as he mentioned.
One by Mr. Turnbull.
That was formal. My apologies. I missed
There's one by Mr. Turnbull that removes summons to re-invite. I guess I'm just, because that's not the amendment, but I would say if we had something like re-invite and, if necessary, summons, that gives ample latitude to the clerk. But that's not the amendment on the table, and I'm not moving that amendment. I'm just thinking out loud. But the amendment is from Mr. Turnbull to remove summons to re-invite and change the date to the 12th. So that's what's up for discussion right now. Mr. Massé, did you want to intervene?
Yeah, that might be the best way to do it is, so I guess here's my concern is like you don't really want to have to summons one if we don't want to, but if somebody's going to be leaving the country and can't be here, then we lose control altogether. And I was there for originally when the minister was at, and I still don't think that the workers are getting the best due process. And so if I have to vote for this amendment, I will not support it because I will fall to getting the summons. I don't really want to summons anybody here, but at the same time, because of the workers and the way that they are still compromised in this, I can't support them not having their day. So I don't know if there's any other way to do this, but I can't support, like, if we just do it this way and then nothing happens, then I'll regret that. But I really don't want to summons anybody either. I mean, it's a tough thing to do, and I think we're all taking it seriously. If there's a way to put the two together, I would be open to that. I don't have a solution though at the moment. I'm trying to think of how I could word that.
Monsieur le Président, je vais...
Just one second, Monsieur. Yeah. Just the clerk has highlighted something quite obvious too, but there's time between now and the 12th. If we are to reinvite the witness, as proposed by Mr. Turnbull, we'll have other meetings until then, and we can see. And just maybe as a note, the witness is, when it's now being discussed that she is leaving the country, she's offered to appear on the 12th. It's not there's no. Just so we're clear on that. I have Monsieur Lemire and then Mr. Turnbull.
Je pense dans un premier temps.
So I think that it would be wise to split the motion in two, to have two separate votes. And then when it comes to the word summons, Madam Clerk, could you give us the consequences of refusing a summons, which might be foreseeable in the current case? So I think that there's a contempt to Parliament. That's what it would be. That's the result. So given parliamentary procedures, I'm sure that we won't be locking her up in a dungeon or anything. No, we'd have to ask the Speaker of the House what the actual consequences would be. But really, I don't think that that's where we are at the moment. So we have the amendment proposed by Mr. Turnbull, so re-invite rather than summons and change the date to the 12th of December. Are there other comments, or should we go to a vote on Mr. Turnbull's amendment?
Summoning somebody is a serious matter. I take it very seriously. And I don't think it's necessary given the fact that Ms. Fisherin has said she's willing to appear on December 12th. So why wouldn't we just re-invite her? And then if for some reason she doesn't actually appear on December 12th, which I wouldn't anticipate given the fact that she's already responded to the committee to say that she would be available on that date, then we can deal with the matter after that. But to me, to use a summons when it's not absolutely necessary is, in a way, it's overstepping in terms of our power as members of Parliament, in my opinion, because it should be used as a last resort when someone is completely unwilling and has been invited, and it's like, okay, no, you come to the committee. And that hasn't happened in this case. And obviously, we've already had the discussion that, in fact, the committee hadn't deliberated on her being invited at all. And the motion itself is a bit confusing, so perhaps I can understand that, but I've already made that point.
And true, the motion was not very directive, and it is within my purview as chair to invite witnesses. We do it all the time with the clerk and the analysts on various studies. But I'll yield the floor through to Mr. Perkins on the amendment.
Thank you, Mr. Chair. And in the spirit of the reasonable, I think, proposal that MP Turnbull just made, and because the witnesses are here, I'm willing to accept it on the understanding that if she doesn't appear, then we'll issue a summons.
So the amendment is re-invite. The committee therefore re-invites Annette Verschuren to appear before the committee in person for a period not less than 1 hour no later than December 12, 2023. And the rest stays as is. That is the amendment.
On peut même réinviter fortement, je pense, dans les circonstances.
We can even strongly reinvite in the circumstances. It's a sub-amendment then, I think. Mr. Massey, you have the floor.
Can we just leave this to you to come back to us on Tuesday? And if you get a confirmation and you feel confident in that, then we don't even have to have a motion for this, and we just move on from there and we'll revisit it. Just let it go like that. And I'm totally comfortable leaving it in your hands, and you could come back and tell us whether this is going to happen or not, and then we can go back to a motion. We don't have to go this far.
Okay, well, then I would need unanimous consent to withdraw the motion. Do I have unanimous consent to withdraw the motion? And we move on? Mm-hmm. Perfect. Thanks to all of you. And I'll briefly suspend so that we can start this study on STTC. conformément à la motion adoptée le 7 novembre.
Pursuant to the order adopted on November 7th, the committee is commencing consideration of the study on the recent investigation and reports on Sustainable Development Technology Canada. I'd like to welcome our witnesses. We have two of them today. Jeffrey Cape, Chief Executive Officer, Our House. He's here online. And we also have André-Lise Méthode, Founder and Managing Partner, Cycle Capital. And she is here in the room with us. Thank you both. I'm sorry for the short delay, and I will now give the floor to Mr. Cape for 5 minutes.
So I have very brief remarks. First, my name is Jeff Cape. I was on the board from 2016, probably early in 2016 until October, end of September, early October 2022. I was invited to the board or nominated by the board by Susan MacArthur through Members Council, so it was a non-political invitation. I served as chair of the governance committee for roughly 2 years. My experience with the board was excellent from beginning to end. It was a very professionally run board. I've served on 2 Crown Corporation boards over the last number of years, and a number of non-for-profit boards and private sector boards. And SDTC was unquestionably one of the best I've ever served on, both at the board level and as well as at the management level. So looking forward to the conversation ahead.
Merci beaucoup, Monsieur Cape. Madame Méthode, la parole est à vous.
Alors, merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair and members of the committee. Thank you for having invited me here today. I would like to tell you a few things about myself first. I grew up in Bécomo on the North Shore of Quebec. And for as long as I remember, I have always lived beside the Fleuve Saint-Laurent. Throughout my career, I worked for the government for Lucien Bouchard, who was premier at the time, and I have devoted my life to the development of new technology and the fight against climate change. As a geological engineer, I have been working on this issue for over 25 years, and I have dedicated my entire career to building a company that combines ecology and venture capital. It was a surprising union 25 years ago. My contribution to Sustainable Development Technologies Canada was to get involved in the Canadian ecosystem to build the global economy of tomorrow. I'd like to start with my involvement on the board of SDTC from June 2016, following my appointment by the Council to September 2021. In the context of my commitment to SDTC, I've always acted with complete transparency by declaring all conflicts of interest, whether real, apparent, or potential. Companies in the Cycle Capital portfolio, in which we generally hold a stake, range on average from 4 to 30%. Companies likely to attract future interest from Cycle Capital, because we generally see projects coming long in advance in my field, and situations that could be perceived as conflicts that have all been brought to the attention to SDTC Governance Committee. Even in cases of doubt, I have chosen to recuse myself. I am convinced that my actions demonstrate the seriousness with which I take this process in all situations. As for the universal and equitable emergency aid granted during the pandemic to all organizations in the portfolio that met the conditions that had already been pre-established by SDTC, I would like, if you allow me, to go back in time a bit and bring you back to March 26, 2020. At that time, schools were closed, Quebec was preparing for a general curfew, supply chains were disrupted, our entrepreneurs were concerned, wondering if they would go bankrupt and if they would have to lay off their employees. It is important to note that a number of government programs, both at the provincial and federal levels, were essential to keep our businesses afloat during that difficult period in all sectors of activity in Canada, from Imperial Oil to the local restaurant. With regard to the measures that we put in place when I was at SDTC, they were measures to protect Canadian businesses, to protect the intellectual property of Canadians' work, and to prevent foreign interests from acquiring them in China, for example. Studies have shown that in Canada, green technology enterprises are underfinanced, sometimes half of that of the financing for their American counterparts. weakening those companies by refusing to support them in a period of crisis, and that is a way not to support the Canada of tomorrow. I would also like to highlight that during my conversations on the board, we obtained a legal opinion from a lawyer at Osner, and that is a legal opinion that stated that there was no conflict of interest given that the measure in question was universal, equitable, and exceptional. And it was applied equitably to all of the businesses that had benefited from SDTC in the past. In conclusion, given this unprecedented situation, it had become imperative to protect our technology enterprises and to protect Canadian know-how and guarantee the survival of our industry and green technologies for the future. Investing in Canadian green technology companies goes beyond a simple economic consideration. It is a commitment to this country, to the environment, and to all of our children. By supporting these businesses, we protect our technological sovereignty. We create sustainable jobs, and we help create a more green and sustainable future for all of us and contribute to the just transition. I know at Cycle Capital, we deployed more than $12 billion of investment and $2 billion in Canadian companies. And today, our portfolio is worth over $3.2 billion. And we created 1,300 high-tech quality jobs in Canada. Engineers, PhDs, and experts on this issue. And now, ladies and gentlemen, I am ready to answer your questions and to participate in this discussion collaboratively. Thank you. Thank you, Ms. Mito. Mr. Perkins, you have the floor for 6 minutes.
My first question is to Mr. Cape. So you, in your opening statement, Mr. Cape said that you served from early 2016 to early 2022 on the SDTC board. Is that correct?
That's correct. Yeah, well, later in 2022, not early 2022.
For some time on the board, I think the latter years, you chaired the governance committee?
That's correct. Roughly 2 years. I don't know exactly how long it was.
And a couple of years ago, or a year or two ago, the board passed a policy of a cooling off period for the directors who were not GIC appointments. Is that correct?
I'm not sure that was actually formally in place until shortly after I left. It was one we were considering instituting, but it wasn't yet in place.
Actually was passed. So I'd like to know, in the time after you left, did you ask and interact with management of the board seeking to get funds from SDTC for our house that you are the president of now?
There was a prior CEO of the company, and the owners and managers advanced a proposal well before I participated. So yes, but it wasn't from me. It was from
them. Contacted the management at SDTC. You are under oath. You never talked to canvass the management or any board members at SDTC to talk about funding for the company you're now president of.
Under management, I might have spoken with one particular individual at one point about a possibility of the prior grant application made by Leith Moore, the CEO then.
Madame Mito, you're the managing partner, as you said, of Cycle Capital. I believe you're also the founder of it, and it was founded, I believe, in around 2009 with a focus on investment, private equity, buying ownership as a venture capital firm in green tech funds. Is that correct?
If I've understood your question, yes, we are a private investor with a number of investors in our funds.
Our own, obviously, as any private equity firm has, it has the principal's money in it as well.
Yes, it does. My capital and the capital of my colleagues.
Shortly after you founded the company, you hired the current Environment Minister, Stephen Guilbeault, to work as a strategic advisor from 2010 to 2019. Is that correct?
Oui, Monsieur Guilbeault a été avisé.
Yes, Mr. Guilbeault was a strategic advisor from 2010 on, yes.
Jusqu'à ce qu'il soit élu en 2019.
You had mentioned that you were appointed the board chair of SDTC in 2016, 1 year after the Liberals won the 2015 election, and you sat on the board until 2021. And you, I believe, after you left that, you've now been appointed to the board of the Canada Infrastructure Bank. Is that correct?
J'aimerais revenir sur un point. Est-ce que c'est possible?
I'd like to come back to something. Is that possible, Mr. Chair? Yes, go ahead. Yes, you stated that it was up until his election, but in fact, we have a letter of resignation of Mr. Stephen Guilbeault indicating that he was going to be running. We received that letter by email on June 17th, 2019. So we ended our business relations with Mr. Guilbeault on that date.
So before you were appointed to the board, the companies that you have invested in had received $93 million in grants through Cycle Capital from SDTC. Is that correct? I have a list, which I can table with the committee if you like. You list them as investments on your website. GAN Systems, Enercom, Encilium, Agrasoma, Concentric. I can go through the 17 to 19 companies.
En fait, plusieurs de nos sociétés en portefeuille.
Well, a number of the companies in our portfolio received either before our investment or during them. There are 4 of those, or after they got investments from SDTC. And during my time on the board,
Mr. Perkins, just if you can let the witness finish at least this
answered my question, and I'm moving on to my next one since I have limited time. The next question is, while you were on the board, Cycle Capital, the companies you invested in received, those companies received $42.5 million from SDTC. These are companies that you have a financial interest in yourself personally and your fund, $42.5 million. And I can table those companies if you like too.
Oui, ça me ferait plaisir qu'on puisse regarder parce que j'ai.
Yes, I would like to look at it because I don't have the same figure as you do, and I would be pleased to calculate it with you.
Ekerim. I don't know if I'm pronouncing it right. ENEKERM. MindSense Technologies. Spark Microsystems. Concentric Agriculture. Polystyrene. They're all listed on your website as investments.
Absolument. Laissez-moi clarifier quelque chose.
Yes, but I'd like to clarify something. I will give you the facts. So since my arrival in 2016 on the board of directors of SDTC, companies in our portfolio, Cycle Capital's portfolio, there are 4 companies that got support. There's MindSense, $4 million. We have 9.6% of that business. There's also Green Mantra, 19.5%, and they got $2 million from SDTC. There's InnocuCall, $1.2 million. We have 28% of that company. And Polystiver, $3.5 million. We have 8.5% holdings in that company. So I'll take the example that you mentioned, Spark. Spark got money in 2016, but we invested, Cycle Capital invested in Spark at the end of 2020. So SDTC's investment was far before our investment, 3 years before.
Monsieur Perkins, je m'excuse.
Turnbull.
Well, thanks to the witnesses for being here today. I know this is a hot topic for this committee and some others, but looking forward to your testimony. And I know that SDTC has been around for about 22 years, if I'm not mistaken. And I know that it was, in fact, awarded an extra $325 million in around 2013, which I think is a testament to the fact that the organization has been recognized by multiple governments as doing some really great work. that doesn't solve the issue at hand, which is really talking, I think, about board governance and ensuring both us as members of Parliament and I think the general public that the funds that the organization presided over and distributed were done so in a way that hopefully navigated the challenges and made sure that you abided by the highest standards of governance. So I think obviously that's a balancing act, but it's important for us, I think, as members of Parliament and this committee in particular, who does have the job of holding government to account on everything to do with industry and its large portfolio. So given the fact that SDTC falls under that portfolio, I think it's important that we have these debates and discussions. So I know that that we've learned from investigations that were initiated by the minister and the committee testimony that we heard around conflict of interest policies at SDTC in the past. They left a lot to be desired, if I can say quite frankly. Board members didn't necessarily recuse themselves from decisions where they had conflicts or where there could be perceived conflicts, or at least that's what we've heard. And if they did recuse themselves, those things were not necessarily noted anywhere. And decisions were taken unanimously without any notation of dissenting votes. Board members, including the chair, gave money to their own companies in some cases. So can you comment, I'm going to start with you, Ms. Meto? Did I say it right? Can you comment on some of these challenges and your experience while you were on the board?
Merci beaucoup pour votre question.
Thank you very much for your question. So I'll answer for myself. And in my case, I have always called out conflicts of interest. I even have a letter here that confirms that I followed all of the rules. And it was also something that was observed by a representative of the minister, a deputy minister, I believe. I'm not very familiar with the nomenclature, but it really, at every meeting we had to declare any conflict of interest, real or apparent, and recuse ourselves. That was our responsibility. And this is a letter that states that I followed all of the rules, and I can provide it to you if you wish. With regard to the minutes, you are right. And I think that all organizations and all boards where I have sat, there's always room for improvement. I left the board of SDTC over 2 years ago, so I can't judge what has happened since. I can simply talk about the time that I was there. I'll give you a very concrete example. One of the minutes, because I did reread the minutes over the weekend, we stated that we were investors in Spark, but in my declaration of conflict of interest, I stated that Spark could be an investment, but wasn't one, and it was not written or taken down in the minutes properly. So yes, I agree, there are challenges.
And so if I could just follow up on that, were there times where you had to recuse yourselves from decisions on the board as a result of a real or perceived conflict of interest? And Mr. Cape, I'll ask you the same. Maybe I'll start with you.
Oui, je me suis récusée.
Yes, I did recuse myself each time I had declared a real or perceived conflict of interest. I recused myself each time. It was the current practice, but it wasn't well taken down in the minutes.
You did recuse yourself.
Yes.
How many times roughly would you say that you had to recuse yourself?
Bon, je peux vous assurer que dans les...
I can assure you, but that in the 4 real conflicts of interest, I recused myself, and then and there were 26 perceived conflicts of interest. But because I am not now a member of the board, I don't have all of the figures, but I can say at least 35 times. But there are 4 real conflicts of interest where Cycle Capital was already an investor in the company to which SDTC was about to give investment funds. And so I think there's a very important nuance that has to be kept.
Thank you for that. And Mr. Cape, maybe I'll go to you. Could I ask you the same? How many times, or I guess the first question is, did you have to recuse yourself at times while you served on the board from a real or perceived conflict of interest? And could you give us the estimated number of times if your answer is yes?
I felt like an outsider. I had no conflicts and no recusals ever required. So I never did sit out on those situations.
And sir, as the result of your work on the governance committee during the time that you served on the board, would you say that improvements were made to governance procedures and processes? And if so, maybe you could tell us why we've heard, at least in a few cases, that these recusals were not documented anywhere. I would think that they should be documented. Could you speak to that, please?
A very brief answer, Mr. Cape, please.
Yeah, I certainly imagine these would have been recorded properly. They certainly were managed rigorously. The conflict of interest policy was well understood by all board members. They were reviewed each year by all board members. Any orientation program for new board members, this is one of the primary themes. So it was a well understood policy and it was rigorously managed. We had legal counsel, corporate legal counsel in the room that managed the process. Not being documented was a mistake. Obviously, I'm not aware of that particular challenge, though.
Merci. Monsieur Lemire.
Thank you, Monsieur Lemire. Thank you, Chair. First, I would like to highlight that your CVs, both of your CVs, are very impressive. You are pioneers in investment in sustainable development and new technology that hopefully will save the planet. What we have before us now is of concern. Monsieur Méthode, I would like to say that your attitude, your very calm attitude, is very reassuring. But I would like to come back to the COVID context. And I remember the work that we did at the time in this committee, and there was a bill for Investment Canada, and we wanted to save our companies from devaluation. You mentioned that in your opening remarks. So I imagine that it had an impact on the work that you were doing on the board. You wanted to save companies. What would have happened if there had been no safety plan to save clean energy companies during the pandemic? Answer. Well, we were receiving phone calls from entrepreneurs at Cycle Capital, and they were panicked because generally those kinds of companies don't make a profit. That's why they couldn't really be eligible for other programs, because for technology companies, usually there's a lot of investment before you can start to see any profit. So these companies were wondering whether they were going to go bankrupt or whether they would have to lay their employees off. And losing resources, losing employees means losing what you need, because you can have intellectual property, but if you don't have the engineers and the talented people who can actually put it into effect, well, then you cannot become a viable company internationally. So I think that what could have happened, well, there are a number of potential scenarios, but it would have depended on how long COVID lasted. Now we know, but at the time we didn't. And those companies would have been truly undermined. And so when you talk about intellectual property and new technologies for water treatment, for example, about 85 or 90% of the intellectual property for that kind of technology is in Chinese hands. And so you have to understand that any intellectual property here would have been a target because can you imagine having to put that aside for 2 years? Well, if you do that, then you have to find employees 2 years hence who actually understand what is going on and who can understand what the real market deployment of the technology would be, would involve, that know-how. So I think that I would have been more ashamed to be here before you and to be asked why we had done nothing. I am very pleased that we did something and that this committee is looking at that. Yes. I remember there was a real risk, and at this committee, we had mentioned that Air Transat had been devalued. And in your case, we're talking about companies that are emerging, that have know-how, and that need patents, etc. But I'd like to go back to the heart of the issue and your time on the board of directors. So I like the way you said it. You declared the real apparent or potential conflict of interest and the need to recuse yourself. But could you tell us how many people who were in a conflict of interest when there was a vote around the table on the pandemic emergency measures? I don't have the status of all of the members of the board in front of me, so I can't give you the actual number, but I can tell you that the internal practice was for people to recuse themselves. And we had a good discussion, and there is one set of minutes that's very well written. That is about the discussion that we had precisely on the pandemic measures. We had a lawyer present. I have to remind you that I'm an engineer and I'm in finance, and for me, my role on the board was to look at the financial and the technical aspects. And I followed the lawyer's opinion as everyone else did. Question. So I imagine that with regard to the conflict of interests, we might get the answer if we adopt the part of the motion that deals with that. But with regard to the emergency fund, you declared a conflict of interest, or at least 4, but you did not recuse yourself concretely. Why did you not do that when you voted on the emergency fund? Well, I considered that the debate that we had enlightened us enough, but I could also reiterate what the exposure of our funds was. So we were looking at 38.5 million in all. Cycle Capital funds in the companies that received that money was 0.26%, because Cycle Capital did not have 100% of the holdings in those companies. It was 5, 10, 15. So 0.0026% is $996. The figure was missed by the interpreter. So when it comes to 0.76, so $298 is what the exposure was for all of the companies that received COVID funding from SDTC. So let's come back to the exceptional context of the time. I'll ask the question again. If you had to redo it, would you act differently? Answer. When I look at the situation that we're in right now economically, and when I'm not an economist, but you just have to read the newspapers to realize that there's economic risk. I think that we were able to protect our economic future. I think that the hundreds of companies, some of those 100 companies that got funds from SDTC will be the green Googles of tomorrow in Canada. So I think we could have done better, probably. But I think at the time when we did not have vaccines, when we couldn't visit our grandparents, our parents, when our children were not going to school, that was the only decision we could make to really protect our economic future in Canada. Answer. I imagine, I really hope that all of the witnesses at all of the other committees will be as transparent as you. Thank you, Mr. Lemire. Mr. Massey, you have the floor.
Mr. Chair, and thank you for being here today. How did you get appointed to the board?
Alors moi, j'ai été nommée, il y a 2 processus.
So there are 2 processes, and I was appointed by the members of the board. I was co-opted by the representatives of civil society under the chair of Jem Balsillie, the founder of BlackBerry.
The other process for members to get appointed?
Bon, l'autre processus. J'ai pas fait ce processus.
That's not the process that I went through, unfortunately. So I'm sorry, but I think that really for me it was civil society.
Non, je sais comment les boards, pas en détail, mais tout ce que.
I don't know the details of it, but I know that you present your candidacy and it's the government directly that decides, rather than being members of civil society, and as it was in my case.
At the end of the day, I guess we'll get that, clarification is maybe I can put that as to the table as how to, who appoints the actual board members. I understand Madame Matheau is appointed by than those that are appointed, but I want to know who actually appointed the original board members. And I'm going to make sure it's clear for the public too. So on this board then, it's comprised of a number of different people who may or may not have several companies that SDTC then can provide financial assistance to.
Oui, je pense que oui, c'est possible et il y a une raison.
Yes, it is possible, and there's a reason for that if you would like to hear the reason. Do you want to hear the reason?
Yeah, well, I'm sure this expertise or this, and there'll be different things on that. But I guess the thing is, so walk me through how you recluse yourself during the meeting. So I have meeting minutes here where some of your companies received some money, and it says that it was unanimous. Now, you may have reclused yourself. Does that mean you actually leave the room and then come back? Walk us through that, if you could. Thank you.
Alors, quelques semaines, ou en fait 2 semaines.
So, about 2 weeks before the board of directors meetings, we got a list, and we could say, listen, I have a conflict of interest with such and such and such a company. There were some board meetings that I was not at, and some companies in our portfolio were receiving money, and I wasn't even at the meeting. So that generally is in the minutes when there's an absence. But when I was present at the meeting, I would leave the room. That is something that all board members did, and that's something that the minister, as a representative, could see each time.
Well, you would come back. Did you learn then what the vote was? Was that provided to you? I know the minutes show that. And this is, I think, where there's a difficulty I think some of the public and others have is that then, it seems pretty comfortable, you come back and it's unanimous. So it's kind of like rotate a person in, rotate another person out, rotate a person in, rotate a person out because it's unanimous. And so that seems like a very cozy way of going through things. And I have some minutes here that don't even show that, they're always unanimous. And so... what do you think to that? I don't know.
Okay, donc je vais répondre aux 2 portions de votre question.
So I'll answer both parts of your question. So when we left... Yes, thank you. Sorry. It's a bit stressful. I don't have a lot of experience with this. So when we left the room, first of all, we didn't have the information, and we came back. We didn't know what the decision was, and we were never informed about the debate. So I never found out what was said about the companies in which Cycle Capital had an investment when they received money from the SDTC. That's the answer to the first part of your question. The second part of your question, the board would take decisions, and there were significant debates, and there was work done by the whole team of SDTC, the very competent people, technicians, engineers who examined the issues, and they did wonderful work. And I could tell you that one board meeting for SDTC involved about 10 hours of reading. So there was reading to do, and then we debated the investments in depth.
Member got the same package, though. So say, for example, you would then get your package, you look at it, find out, A, I'm in a conflict of information on this issue, and then you would know that issue, though, and that, so does somebody screen that? Or you just self-choose which conflict of interest, but you still receive the same package as everybody else? Is that kind of what happens? And then what would stop somebody, I guess, from picking up the phone or talking to another board member outside of the board meetings about their own projects and own companies, especially since you're spending all this time together?
OK. Alors, avant de recevoir...
So, before we received the package, before the documents, we would get a list. And our list at Cycle Capital, we had a mechanism. So we have 1,200 files a year. I don't know all of them by heart. So there was an analyst at Cycle Capital that would take the list and would tell me, we invest in this one. We are looking at this one for investment. We've been doing so for 2 months, et cetera. And then GHSAT, for example, I declared my conflict of interest. I recused myself because my niece works in the upper management. So it's the analysts who first looked at the list and looked at the companies in the pipeline, the ones that we invested in, and then more personal cases like my niece. Sorry, Mr. Massé, that's all your
5 minutes.
Okay, sorry, just going to get my clock going. Thank you, Mr. Chair. Madame Otto. So in the 9 years that Stephen Guilbeault worked for you, STDC made announcements on the companies you have listed as invested on your website. The amount totals $111 million on announced stuff. So it wasn't a question. It wasn't a question. Secondly, during the time that your company has existed, announced projects from SDTC have totaled $143 million, including $8.5 million, which was given to ViewReal announced after you departed for the Infrastructure Bank of Canada. So it seems to me that, being and knowing and employing Liberals apparently is a fairly profitable thing for directors of SDTC. So I would like to know, when did you join the board of the Infrastructure Bank?
Est-ce que c'est une commission sur la banque?
Is this committee dealing with the Canada Infrastructure Bank? Do I answer that question? No. I think that this study is on SDTC, so it may be outside of the scope of the study, but it's also a matter of public knowledge, so you can ask I was just asking the question.
I gave a very lengthy description of her qualifications. One of those is that she is now on and transferred the Infrastructure Bank. It's a simple question. I don't know what you're afraid of. What year did you join and what time of the year did you join the Infrastructure Bank?
Permettez-moi peut-être de...
It's on your CV on LinkedIn.
Vous pouvez répondre à ma place, monsieur, j'ai aucun problème.
You can answer for me, then. I have no problem.
The Infrastructure Bank of Canada. And in February 2023 of this year, Annette Vacherian's company, NR Store, received a $170 million financing for the Infrastructure Bank after you had left the SDTC board. Is that correct? Were you part of that decision at the Infrastructure Bank board?
Je n'ai aucun intérêt dans Enerstar.
I have no interest or holdings in Enerstor. That's what you're talking about?
When, in February 2023, the Infrastructure Bank granted financing to Enerstor, Annette Vacherian's company, $170 million.
Je n'ai aucun intérêt dans Enerstar. Je comprends pas.
I have no holdings in Enerstor. I don't understand why you're asking me this question.
I didn't ask you about holdings. The witness is refusing to answer the question. The question is, were you on the board in February 2023 of the Infrastructure Bank of Canada?
Je vais regarder ma date de nomination, monsieur, sur mon LinkedIn.
I'm going to look at my appointment date on LinkedIn because, sincerely, to be very honest with you, I did not prepare myself to answer questions.
This year? Oui. So you were on the board of the Infrastructure Bank, and the Infrastructure Bank granted financing to Annette Vacherian's NR Store, which also received money prior to her joining the SDTC board. There was a nice, cozy relationship going on between board members, such as yourself, Annette Vacherian, and other directors we will call before this committee. Can you explain to me why you received, did you recuse yourself on the 7 times that you were a board member, not 4, the 7 times you were a board member, as reported on the STTC site, 7 times your companies, while you were on the board, received funding announcements. Did you recuse yourself on all 7? You said you recused yourself on 4, but there are 7 listed on the STTC website.
Est-ce que je peux répondre, monsieur le président?
May I answer, Mr. Chair? So I had to recuse myself many more times than that because I declared my perceived conflicts of interest. There were board meetings where I was absent, and there are only 4 companies in my portfolio that received money from SDTC while I was on the board of SDTC. If they received money after I left STDC or before I was on the board, they would not technically in an area of conflict of interest with regard to governance. What the board of directors decided before I arrived on the board and what it decided after does not concern me.
So, Monsieur Sorbara, Mr. Perkins, your time is up. Mr. Sorbara, the floor is yours.
Thank you, Chair, and welcome to the witness, one in person and one virtually. Obviously, a number of questions that were asked today. Ms. Meadow, bienvenue ici aujourd'hui, ce soir.
Welcome.
I've taken a look at Cycle Capital, the firm that you are integral to, if I can use the word integral to. And it's obvious that your firm has been around for a while. You've made probably a lot of investments into a number of companies. And in that investments, you obviously check out the corporate governance structure of all companies you would invest in. And it sounds like you sit on a few boards. You sat on the board of SDTC. And my understanding is correct, you sit on the infrastructure bank board, obviously acknowledging your experience and so forth within the investment industry. How would you judge in your tenure the corporate governance structure that was in place at SDTC?
I want to make sure that I understood properly. You talked about the governance structure. Is that your question? Yes. Is it effective? Answer. So when I arrived, the foundation had been around for a few years already. And in fact, my colleague on the screen said so. There was strong governance, and people would recuse themselves and declare their conflict of interest in advance. It was well structured, but perhaps poorly transmitted in the minutes.
Okay. That's I do want to put a chair on the record that with regards to the chair of the board, Annette Verscherian, whether she's a chair or not, or independent of that, that she was a maximum donor to the leadership campaign of Mr. Jean Charest. Because we heard from the other side. Just had some interruptions there from the other side, from a gentleman most times, and so I will say that again. Annette Verscherian was a donor to Jean Charest's campaign. There was some insinuation that being a liberal is this or that, and it was unfortunately that was pointed out. To the gentleman that's on virtually, what was your experience with SDTC?
In the sense that I was a board member from 2016 to 2022.
You sit on the board, you have your quarterly meetings or monthly meetings, however it's structured. Someone should be there to take minutes. Been around for 20 years. There should have been some sort of passing the baton experience. There's in-house counsel. Can you explain, give us some granularity on that?
Well, I could stand by my earlier comments whereby I viewed the processes of governance associated with the board to be excellent. The diversity of board members, the robust discussions, the policies in place around conflict. It's obviously specific to today's discussion were rigorously maintained and monitored. The process for minutes, though, I suppose maybe there's some debate as to whether or not they were comprehensive enough in various details. clearly they were lacking in some corners. They were certainly sufficient as we saw them as board members at the time. The addition of new board members was obviously was very carefully considered and again rigorous in the sense we were looking for the right sort of diversity of voices and balanced discussions at the board level. So the process for bringing in new board members was always about trying to make the board better.
If I can interject, when there were contribution agreements signed with companies, I take it the board would look at all the investments that were decided upon by SDTC, correct?
Just to look for a little clarification in your question, are you asking whether or not the contribution agreements, well after a board decision was made to approve a grant, whether they came back to the board?
Yes, even before or after. Like there has to have been a process by the investment committee that would have said yes or no, yay or nay, and then the board at some time will have to review those decisions.
The decisions to invest in a company were made at the board level after thorough review and debate by various committees leading up to management and board related committees. But the actual review of contribution agreements was not something that was routinely brought back to the board. They were part of management responsibilities.
Thank you very much, Mr. Sorbara. We have a hard stop at 6:38, so that gives us 4 more minutes. I'll give 2 to Mr. Lemire and 2 to Mr. Massé. Monsieur Lemire, la parole est à vous.
Merci, Monsieur le Président. Madame Méthode.
Thank you, Mr. Chair. Ms. Mito, with regard to the type of expertise required to analyze investment projects in green technology and emerging technologies, what is required with regard to the risk capital and what needs to be invested in? That kind of expertise must be quite rare. So it must be difficult to bring people with that kind of expertise around the table, no? Answer. I would say that 15 years ago, approximately, there were maybe 15 or 20 people in Canada who were starting to develop that expertise. But today, there are far more of us. So that's excellent news because there are a number of people who are concerned with that issue now. And if I understand it properly, the Government of Canada itself did not necessarily have the expertise to analyze that kind of project. So I guess people at NRCan or in industries are particularly good at evaluating oil and gas projects, but not necessarily green ones. So you were saying that there is half the amount of investment in green technologies here than in the U.S., but I wonder if you were to compare that amount of investment with the investment in oil and gas companies, I imagine there's a huge imbalance. So if you look at that imbalance, do you think that the federal government on its own is able to evaluate things? If we go back to COVID times or in 2015 or today even, is the federal government able to evaluate the potential of green technology investments? Answer. That technology sector is an emerging one, and I think that there is a great advantage to working together in the private and the public sector. You're talking about oil and gas. I had very good experiences with people in the oil sector. Mark Little is one of the advisors. He's the former president of Suncor, and they really did contribute a lot. So I think that everyone can contribute because we have to build up the sector quickly because we only have a few years ahead of us to stop climate change. So with regard to the credibility of SDTC, by trying to discredit SDTC, is that a way of discrediting investment in green funds, according to you? Answer inaudible. So you have the floor. But it has to be about the topic that we're discussing today. Well, yes, but earlier, the second part of this study of the motion was postponed, but I think that it's irrelevant given what we've heard today, namely that the committee asked SDTC to declare or to provide any declarations of a conflict of interest from board members since 2015. So I think it's relevant to ask that, given that the committee has ended its debate. So I think we should actually make that request now as a committee. So there's a motion now that has been made by Mr. Lemire. That is the last sentence of the motion tabled by Mr. Perkins that we discussed earlier. So further, that the committee request SDTC to provide any declarations of a conflict of interest from board members since 2015. So are there any comments about that, Mr. Turnbull?
So why are we picking 2015 when we know the organization's been around since 2001? So 22 years that this organization has existed. It seems 2015, the only rationale I can see is the correspondence when our federal government came into place under Liberal leadership. So I would say that sort of makes it look like it's really biased towards trying to dig up some dirt on Liberal government, which we've heard opposition members on the Conservative side repeatedly say things that are untrue. I would just note for the record that Annette Verschuren was appointed by Brian Mulrooney, Stephen Harper, and Jim Flaherty, my predecessor, at least three times by Jim Flaherty for different positions. So just to claim that this is a green Liberal slush fund, as Mr. Barrett has made claims to in the House of Commons multiple times, this sort of starts to look like it's very much just digging for or fishing for some goods on the government. So I really think we need to consider the dates and timelines and go back to perhaps the beginning. And Mr. Chair, I know that the meeting had a hard stop at 6:38. But I'm happy to stick around if this is really what we want to be doing. But you said it was a hard stop, so
I'm checking with the clerk when's the very latest. But we started at 3:38, so usually it was agreed that we had 3 hours, so 6:38. But the clerk is looking into it. In the meantime, Mr. Barrett,
Well, thanks, Chair. So it's important to note that with respect to the $1 billion Liberal Green Slush Fund, that the Auditor General had given it a clean bill of health up to 2017. So while I am interested in the documents from 2015 forward, I think that some of that has already been pronounced upon by the Auditor General. But I mean, irrespective of who appointed any of the individuals to the board, to other OIC appointments and who appointed them to the board. It doesn't matter who appointed you. If you break the rules, then you need to be held to account for that. And Ms. Verschuren was in fact appointed to the SDTC $1 billion Green Slush Fund by the current Liberal government and has resigned in disgrace. And so the conflicts of interest that the government's review that they commissioned has determined that the conflict of interest policies were not followed. I think it's very important that for that period of time that they reviewed, that to Mr. Lemieux's point, that's the period of time for which we see those recusals, because I mean the in-house counsel. He advised, the one who was advising them on conflicts of interest was the same one who told board members to backdate their conflict of interest documents. So the documents that they do have are highly suspicious at best. So certainly back to 2015, full support from me for that suggestion.
Thank you, Mr. Barrett. Monsieur Lemire.
Mr. Lemire, you have the floor. Could you remind me what the spirit of the motion is? And I think that the point is interesting, and I don't want to decide whether it should be on 2015, be it the Liberal government appointments or not. But perhaps should it be the funds that were spent during COVID times and conflict interests at that point? Or are we really looking at all of SDTC from the very beginning of the organization to the present? So what was the spirit of the original motion, Mr. Chair? And then I would suggest a date based on what we're supposed to be studying. So before going back to that, we're on your motion, Mr. Lemire, and Mr. Turnbull, I'll come back to you. I'm sorry, I'm a little bit distracted because I'm trying to see whether we have a hard stop. I think we're going beyond what we were granted, we were told 3 years maximum. So I think we should also show respect for the resources that are provided to us in the House and that were given to us in addition for tonight. That I suggest that we should continue this fascinating discussion at our next meeting and that we adjourn the meeting today, given that we've gone beyond the 3 hours that were granted to us. Do you agree? Yes? Everyone agrees? Well, then, this meeting is adjourned. Thank you, Ms. Mito. Thank you, Mr. Cape. Thank you to the interpreters, the analysts, Mr. Chair. But there is a legitimate request by the NDP, perhaps to have a last question, because he lost his time. It was my turn, my fault, and I'm sorry about that. Well, yes, but you tabled a motion, so there's not much I can do about that. Thank you. Meeting adjourned.